What's up, everybody? Welcome back to the Court of Random Opinion. My name is Lauren Neidigh. I will probably be joined by my friend Omar Serrato, the Tilted Lawyer. I was on his stream earlier, and he is going to try to join ours, but he'll be on a speakerphone while he's in the car, so we'll see. Rose Gruber says, how do I get the documents? Well, you can go to courtlistener.com, or if you wait until after this stream, I will post a link to it in the description of this video so you can see it as well. We're going to get right into it in just a minute. I just want to give people a chance to filter in here. With these filings from Baldoni's team, I've learned to expect them later at night. So while we're waiting, why don't I throw out this link to a couple of other streamers, see if they want to join us to comment tonight. If not, that's okay, because I know it's later at night. So here where I am in Florida, it's 9:40 p.m. All right. Let's see. I'll send it to Dave. Send it to Dave Neal, but he's probably busy. He's got a baby, so. And I'm just going to give it one more minute, guys, for people to filter in. Okay. Cat Lady Ballerina, thank you for the $5. Will anyone mention Rule 26 tonight? I can't handle filings without them. I think you just mentioned it, right? So, Carol Thomas, we're all here with you. Thank you very much for saying that. Appreciate it. Dragonfly, everyone's talking about that. This is a politically neutral zone, and I don't do that on my streams unless I specifically designate a stream to a political issue, so I'm going to have to ask you to stop that. If it happens again, you're going to have to get a mute. All right. So, here's what we got tonight. This is Justin Baldoni and the Wayfarer party's response to Blake Lively's motion to dismiss the amended complaint for attorney's fees and costs and to strike Exhibit A. All right, hang on one second. There we go. That's always the best read. What's Rule 26? I'm curious. Well, to know what Rule 26 is, you have to follow along the other case that I've been covering, the Laura Owens versus Clayton Eckerd case. Rule 26 plays a ridiculous role in that case, even though it shouldn't. So there's that. All right. I think we have enough people in here to start. What do you guys think? Okay. And remember, guys, before we get started reading this one, what happens is somebody submits the motion to dismiss. In this case, it was Blake, right? Justin and the Wayfarer parties respond, and then Blake will get another chance to respond to this document that we're reading right now before the judge will rule on it. So I know a lot of people see this stuff and they're like, why are they just submitting filings to waste time and shit like that? Like, no, like there's actually a process here. The initiating party on the motion to dismiss does get to, again, respond. And so we'll see what they have to say in a couple weeks, because they get, I think, 2 weeks to respond, 2 calendar weeks to respond to this. So, yeah. Okay. Okay, well, Omar will hopefully come back and join us, but I'm not sure if he can make it in or not, but we'll try. We'll try. Oh, cool, Paige. Thanks for joining. All right, it's been almost 5 minutes, so let's get started, shall we? And also, if you're watching this back on replay, I would appreciate the support if you give this a like and subscribe, and also listen to as much of the stream as you can, but I know some people can't listen to the whole thing, so I will, in the morning, make a short recap of this document. It'll be 4 or 5 minutes long, and I'll post it then. But if you want all the good stuff, stick around. Okay. Let's see. Consolidated Plaintiffs, Wayfarer, Justin. We all know who these people are. Okay. Memorandum of Points and Authorities. Introduction. Since Omar's not here, I'm going to take this off because this makes my head hot. Okay, anyways. The First Amendment complaint contains hundreds of pages rife with factual detail about Lively's calculated efforts first to extort and manipulate the Wayfarer parties into ceding total control over the film It Ends With Us, and then to defame and scapegoat them when her plan backfired. Nonetheless, Lively refuses to accept responsibility for the trial of untold destruction she left in her wake, but she goes further still. Lively asked this court not only to dismiss the FAC, but also award her attorney's fees, costs, and treble and punitive damages for the Wayfarer party's constitutionally protected act of petitioning the court for redress of their grievances. In essence, Lively asked the court to find that she is immune from any culpability for her wrongful acts, and instead it is the Wayfarer parties who must be punished for daring to exercise their constitutional right to seek a remedy from the court for her lies. All right. Wait, is this a new one? Yes, it is. It just dropped. So, okay. And people are asking, I think if Friedman wrote this. Let's see. I'm on page. Let's look at the bottom. Yes, Friedman did write this. Just wanted to check. Both parties have multiple attorneys, guys. So sometimes you'll see a different attorney's signature at the bottom. It doesn't mean that their other attorneys quit or anything like that. Some people read into that a little bit. But it just means that a different attorney at the firm or a different attorney who's representing them wrote it. But in this case, it is indeed Brian Friedman, who is, I think, the people's choice at this point. So, yeah. All right. The motion must be denied. The FAC specifically alleges abundant facts in support of the Wayfarer party's claims against Lively, based both on her own direct actions and on those of her co-conspirators and agents. The Wayfarer parties have pleaded allegations against Lively sufficient to defeat dismissal, and Lively's arguments often border on frivolous. I don't disagree with that. In particular, Lively's argument that California Civil Code Section 47.1 immunizes her from liability would require the court to determine as a matter of law that she acted alone and without malice, and that she had a reasonable basis for her claims. In other words, to make findings of disputed fact not apparent on the face of the pleadings, which flies in the face of the well-established rules governing motions brought under Rule 12b-6. When the court assumes the truth of the facts set forth in the FAC, as it must in ruling on this motion, the only possible result is a denial of the motion in full. 1 second, guys. Okay. What do we think so far, guys? Are we doing all right? I think it's pretty good so far. Teresa S., thank you for pointing this out. If you join the Patreon there, it's free, and you can get updates that way. You do not have to pay anything to get the updates. There are some members-only streams, but as far as these documents and the court case go, everything is publicly available free of charge. So, all right. Let's see. And also, I just wanted to point out, thank you, Amanda Sherbert, for the 99-cent super sticker and the $1.99. I appreciate you. Okay. Where do we leave off here? Sorry, my bad. The Wayfarer parties have pleaded allegations against Lively sufficient to defeat dismissal, and Lively's arguments often border on frivolous. In particular, Lively's argument that the California, yeah, we read that already. Okay. Immunizes her from liability. Okay. All right. Sorry about this, guys. When the court assumes the truth of the facts set forth in the FAC, as it must in ruling on this motion, the only possible result is a denial of the motion in full. Regardless, any technical defects or instances of inartful pleading in the FAC can be readily cured by amendment, which is freely allowed, and the Wayfarer parties are every day obtaining further facts to plead in support of each of their claims against Lively. So that means more evidence is coming out in discovery. Furthermore, The Wayfarer parties can amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines that dismissal without leave to amend is appropriate, Lively is still not entitled to the award of fees, costs, treble damages, and punitive damages that she seeks. The draconian, one-sided sanctions that Lively demands under California Civil Code 47.1b are, in a matter of first impression, barred by the Noor-Pennington Doctrine. I don't know if I pronounced that right, guys. Which precludes the imposition of liability for the exercise of rights protected by the petition clause of the First Amendment. The First Amendment protects the rights to petition the government for a redress of grievances. In other words, the Constitution safeguards Americans' right to ask the government to take action, such as by bringing legal claims. The Noor-Pennington Doctrine bars courts from punishing litigants for bringing good faith claims. That's a good point. Including through the imposition of harsh penalties like the treble damages award Lively seeks here. Because the Wayfarer parties have brought good faith claims against Lively that are neither objectively baseless nor subjectively brought for improper purposes, the First Amendment protects them from being punished for the act of seeking relief from this court. In short, the motion must be denied or, at most, granted with leave to amend. In no event on this motion or at any stage of this proceeding will the First Amendment permit the extreme and unconstitutional award of fees, costs, and treble and punitive damages Lively demands. 2. Legal standard and factual background. Give me 1 sec, guys. Oh, hey, Zach. Oh, Be Better's here. What's up, Be Better? Can I file a motion to deport Ryan Reynolds from Canada? Oh my gosh. Hey, man, do you ever want to come on the show? You should. Be Better if you want. I'll send you a link. I don't know what you're doing right now, but if you ever want to at a later date, we should definitely link up and talk about some of this stuff. If you guys don't follow Be Better on TikTok, you definitely should. I barely use TikTok, but when I do, I watch Be Better. So, oh, I love you too, man. All right. Let's see. Wait, how do I send a link? Can you send a link on TikTok? Give me 1 second. See if I can send. Oh, Omar's back. Omar.
What's up, Juan?
You made it.
I know. I tried to do it when I was driving. It didn't work out.
Oh, you got home? Okay, good.
Yeah.
I was like, your thing froze up, and I was like, I have to kick him out, but I hope he doesn't think it's on purpose.
No, well, I kicked myself. I was like, well, this obviously isn't going to work. So I think I kicked myself. I might have. It doesn't matter.
Mm-hmm. Oh
anyway, what do you got on the docket today? What are we reading?
Justin Baldoni and the Wayfarer team's response to Blake Lively's motion to dismiss.
Oh, by the way, we're like right in the middle of family time, so you're going to hear some small children running around, and I'm going to have to take a pause, and then I'll come back in.
Yeah, that's fine. If you need to come in and out, that's fine. That's fine.
All right.
Let me see right here. I'm sending this message to Mr. Be Better. Oh, I hear the child. Okay. That means I can't say any swear words, Omar. You know, that's like the bane of my existence. Okay.
Well, they've heard a lot worse.
All right. Well, that's disturbing, but we'll talk about that another time. Oh, my bad. My phone went off. Mom, stop calling me. Just kidding. It was my alarm. Okay. We're going into legal standard and factual background. Pursuant to Federal Rule of Civil Procedure 10C, the Wayfarer parties incorporate by reference their allegations in the FAC and the recitations of legal standards and factual backgrounds in their opposition to the Rule 12b6 motions of consolidated defendants Leslie Sloan and Vision PR, together the Sloan parties. And that Sloan also moved to dismiss, and that's been fully briefed. So we're waiting on the judge to rule on that, but he has not yet. He said he wanted to do it quickly after the briefings were, fully completed, but still, we're waiting. Anyways, the New York Times also moved to dismiss, and Ryan Reynolds. Lively and the Wayfarer parties agree that California law applies to their claims. Okay. Omar, any feelings about that?
Well, yeah, I've been saying that. Everybody wants California law to apply. So since we're all in agreement that everybody wants California law to apply when advantageous to them, there's certain aspects that Lively wants to have apply California law, and there's certain things that she would rather it not. Reynolds is the same way. And so I think the judge is going to just be like, you know what? We're going to apply California law.
Yeah.
You can't just cherry pick which law you want for different reasons. And so it looks like, yeah, I think we're going to go by California law for a million different reasons. But the most obvious one is every party has at some points in the litigation expressed a desire to go by California law.
Be better. It's not working. Does not work on phones. There's like an iPhone app or an Android app you can download at StreamYard. That's the only way I know to do it from a phone. If not, we can always link up tomorrow or something because there's another filing coming tomorrow night. So we can always plan on that ahead of time. Helen, I did zoom in a little bit more, but if I zoom in any more than that, I can't see it all on the screen. So hopefully it works. All right, let's see. Argument A, the FAC states a claim for defamation against Lively. Under California law, defamation is an invasion of the interest and reputation. The tort involves the intentional publication of a statement of fact that is false, unprivileged, and has a natural tendency to injure or which causes special damage. Defamation may consist of either libel or slander. Libel is defined as a false and unprivileged publication by writing, which exposes any person to hatred, contempt, ridicule, or obloquy. Is that how you say that? Obloquy? Omar? Do you know?
Obloquy?
Yeah. Yeah.
Hey, am I allowed to hype you up a little bit? I think the people should know. That you once took the LSAT.
Oh, yeah.
And scored exceptionally freaking high on the thing. Didn't you get like a 163 or something?
It was like a 162, I think. And that was a long time ago. It was like 8 years ago now. Almost 8 years ago.
The same score that I got. And that puts you in like, I think the 90-something percentile, whatever, of aspiring lawyers wanting to go to law school.
It did at the time. I don't know if it does anymore, man. These kids are crazy now. Like they're crazy smart.
Kids, I'm going to go out on a limb and say that kids, when you were taking the LSAT, are significantly smarter than the ones taking it now. And I think it's because of ChatGPT, AI, and stuff. All of the shortcuts that are available to kids today.
Fair
anyway,
enough. Yeah.
I'm willing to guess that you could spout off all of the elements of defamation with your eyes closed, given how many times you've read the elements in these pleadings.
My problem is the same problem I had 8 years ago, which is my ADHD brain will not allow me to do that. I know in my gut, I'm like, I know what this is. I've learned this. I've studied it, but like, I can't recite it for some reason. That's just how my brain works. It's like, I understand everything. If you say it out loud to me, or if I read it, I'm like, I totally know what you mean. But for some reason, my brain in its weird neurodivergence is like, nah, you can't say that out loud. So it is what it is. Yeah.
Well, you can't have it all. What can I say?
Yeah, well, says maybe tomorrow will be better. Anyways, we'll link up tomorrow. Thank you for watching and commenting, though. All right, let's see. Lauren is actually somewhat smart. She rode the short bus as a disguise. No, my parents drove me to school. Okay. And also, my dad, Larry N., just invited me to play Words with Friends. So we're all just doing very well over here. Anyways.
I suck at that game.
Dude, I'm going to play you. I didn't even know you were playing that game. Sorry.
Well, I haven't played it because I'm not very good at it.
People do not come here to hear this. Anyways, this is why I said I was going to do a short recap that'll be posted tomorrow morning, because if you don't want to listen to this crap, you don't have to be here. But if you want to follow along with us, I thank you very much for being here. So
I did say I was going to come and troll your stream, and so I think I've been true to my word.
Well, you're a terrible troll, because that was very tame for a troll.
Well, you got a bigger audience now. I got to be carefuler about what I say. Carefuler is the word.
Yeah, dude. Mr. Attorney. That's on the LSAT, isn't it? All right, anyways. You can see the screen, right?
Yes.
I'm just making sure, because if I read too fast, I don't want you to, like, you know what I mean?
I can't see it on my phone, and so you're just going to have to read it to me.
Okay, so the answer was no. Then.
No.
Defamation may consist of either libel or slander. Libel is defined as a false and unprivileged publication by writing, which exposes any person to hatred, contempt, ridicule, or obloquy, which is what we were just talking about, or which causes him to be shunned or avoided. Oh my God, so there's so much I could sue people in middle school for. No, just kidding. Or which has a tendency to injure him in his occupation. Slander is a false and unprivileged publication orally uttered. Okay. Where the defamation is clear without the need for any explanation, it is considered defamation per se, and damages are presumed.
Defamation per se, the motherfucker, man. Hey, I got a dip for some minutes. I will be right back.
Yeah, no problem. I'll be here.
Okay.
You know I will be here. So, okay. All right, guys. Omar's having his family time, so we'll keep going, and he'll pitch in with his legal stuff going on in a little bit. But I had asked, just really quickly, guys, if you're watching this live stream, like I said, I'll post a short in the morning, but I really appreciate the support and you guys watching and just, whatever. Yeah, Omar was talking about, I totally forgot what I was saying, so we're just going to keep reading. Something about the LSATs. But yeah. I took the LSATs forever ago. So I'm reading some of this legal stuff, and I always say, I'm not a lawyer. I don't understand this stuff. And it's like, I think I understand a lot of it, but I can't totally say that I do with any confidence because it's like I didn't actually go to law school. The reason I didn't go is because I didn't want to move away from home again. I went to college. I went to Gainesville. I was a swimmer. I swam at UF for 2 years. I swam at University of Arizona for my last 2 years. Then I went to Tallahassee for grad school, and then I went to New York for a second grad program, and then I came back to Jacksonville where I am now. And we didn't have a law school here, and I didn't want to move away again. So, yeah. That's how I ended up here, and that's why I didn't go to law school. I got into a couple schools, more than a couple schools. I got into several schools, but they were far away. I was like, I don't want to drive 5 hours to see my family again. I'm tired of that. So, and now the reason he brought that up is because they opened a law school here in town not too long ago. And apparently it might work out if I decided to go there. So we're thinking about it. And by we, I mean me. I'm thinking about it, but I haven't really talked to my family about it yet or what that means. So we'll see. We'll see. It's something that I always wanted to do that I might be able to do now, but we'll see. All right. Hopefully you guys can see this document okay. Where the defamation is clear without the need for any explanation, it is considered defamation per se, and damages are presumed. And as long as he's not here, I'm going to take these headphones off because it's hot. Okay. At you to his practice. Dude, I'm in Florida. Okay. Eating lunch in Australia and listening to this. I'm going to be in Australia in just a couple months. So, all right. The definition of libel per se is very broad and has been held to include almost any language which, upon its face, has a natural tendency to injure a person's reputation, either generally or with respect to his occupation. A statement will qualify as slander per se if it charges the commission of crime or tends to directly injure a plaintiff with respect to the plaintiff's profession, trade, or business by imputing something that has a natural tendency to lessen profits. Where the defamation is not per se, oh my God, I zoomed in way too far. Sorry about that. Anyways, where the defamation is not per se, and some explanation is needed to show why the statement was defamatory, the plaintiff is required to allege and prove that he or she suffered special damages, such as harm to reputation, shame, or economic damages. Okay. Here we have 1. The FAC identifies specific and unprivileged defamatory statements. Lively's contention that the Wayfarer parties failed to allege specific defamatory statements made by her fails for 2 reasons. First, Lively is liable as the principal for the statements made by her agents, the Sloan parties and Reynolds. And I know that they don't include Stephanie Jones in there, but let's be honest. Second, Lively herself is alleged to have made defamatory statements. Correct. Lively is liable for statements made by the Sloan parties and Reynolds under the principles of agency and the doctrine of respondeat superior. Okay. It is well settled that, under California law, one who takes a responsible part in a publication of defamatory material may be held liable for the publication. Okay. And we're going to skim over some of this case law stuff until Omar... Oh! You made it! Hang on.
Hi. I was just kind of creeping in the background. I wanted to see if this worked.
Yeah, my bad, man. So
That's
I'm
okay.
always hanging out in the background of Omar's streams, like, hello, I'm here.
Oh, nice.
Yeah. It doesn't give me like a bell or anything when you guys pop in, but that's so
don't
cool.
worry.
Thank you for joining me. It's good to see you.
Thank you for having me. I'm enjoying this.
Okay, cool. So what have you been thinking so far? What did you expect out of, I guess, this this week, I guess, where there's lots of responses to filings going on? And
yeah, I haven't gotten a chance to look at everything. This document specifically, I feel like it's pretty, there's nothing crazy in it so far.
Yeah.
Like,
yeah, not so far.
For me, the highlight over the past couple of weeks was the Stephanie Jones information. That was absolutely crazy.
Yeah. Now, people get mad at me because I like cackle all the time in the Publicist filings. I'm like, but they're the most dramatic.
Oh my God, it's so funny. And
so
I was getting
ridiculous.
messages from people, sorry to derail the conversation, but there were so many people who had worked for Stephanie Jones and their stories were absolutely insane. Like one girl was like sending me pictures of how she had to see the cardiologist because she thought she was having heart attacks because she would just like literally like had to see a cardiologist because of how much stress Stephanie Jones put them under. Like
that's so crazy. Yeah.
Complete universal absolute hatred of that woman.
Yeah, that's so crazy, man. Like I hear all kinds of wild stories, but I'm like so scarcely on TikTok. I feel like because I'm so overwhelmed by everything else that I'm doing. But like when I do go to TikTok, it's your channel. So like I hadn't heard that though about the heart thing. Oh my God.
Yeah,
that's
no, it's
crazy.
scary, but I feel like that was so significant, like that entire filing, because I really think that's the only reason this lawsuit came about. Now that it's like all been contextualized, like I don't know if Stephanie Jones just never sent anything and just shut her mouth.
Mm-hmm.
I don't know that this would have ever been filed.
Probably not. I don't think so. Yeah, that was my tinfoil hat before it was confirmed. I was like,
that's awesome that you predicted that.
Well, I mean, I had to read her initial lawsuit before I came to that conclusion, but I was kind of like, I think she did this, you know?
Right.
But I didn't want to sound like a psycho, so I was like, maybe I won't say that out loud.
No, I think people love hearing predictions, and it makes a lot of sense.
Yeah, I'm just not that confident in my, I guess, guesses and stuff like that, so it takes me a minute to be like,
scary, yes. You can say something and then be wrong, and then people are like, you're wrong, whatever, and then you don't really get extra brownie points if you're right because people are like, whatever, they just move on.
You're right. Yeah.
I think the interesting thing that will come out too is like the emojis that were taken out. Like I was looking into what's the service that you use to like extract data from phones? It starts with
Celebrate.
Yeah.
Celebrate, yeah.
Like apparently, I tried looking into it best as I could. Apparently, that leaves the emojis in.
Mm-hmm.
So the question is like, did Stephanie Jones alter some things before she sent them? That's kind of my theory. I feel like she would do that. Well,
I looked all that up too because as like Celebrate, do you have to have a subpoena for Celebrate to take information off a phone? Apparently, no. So that was interesting to me. But when it came to the emoji stuff like that, I was like, oh, I didn't even know that was a thing. And then apparently it's not. So it's all very confusing. But as far as the Celebrate stuff goes, I'm like, yes, you can get the stuff off the company owned device without a subpoena, but you can't then share that with other people for the purposes of, hey, go fuck them with this. You know what I mean? So
yeah, exactly. And there still hasn't been any information as to like so obviously they didn't get a subpoena because it happened the same day allegedly. Like so did they get one after with like some other case that we didn't see? That would be like the only thing, but even then that's a little bit sketchy. So
yeah, I mean California has some laws where you can do like pre-litigation discovery and stuff like that, but it's very specific and I don't know if it actually met the rules there. So I still think to this day, like Yeah, Stephanie Jones got mad because she heard Jen Abel was leaving. So she goes through Jen Abel's phone illegally, unfortunately, with Celebrite, and gets the information. And then she illegally sends the messages to Blake and her publicist, and it's like, you guys should totally like use this to screw them over. So yeah, crazy.
Do publicists have any kind of, like, maybe it's dramatic, but like fiduciary duty to their clients, or no? I guess it's not like as serious as being a lawyer, but it definitely, at the very least, it's unprofessional. Like there should be some agreements between like a publicist and a client that you're not going to be doing harm to them, right?
I mean,
like,
they definitely have contracts, and that's the whole thing, right? So like, if she was no longer their publicist, I don't know if it would technically be illegal or not, but she's arguing in her lawsuit that they were still under contract. So I'm like, how can you argue that these people, you were still obligated to your clients here, but then also like, you know, do this behind their backs, which is like, I think she's probably going to deny that. She's going to deny I sent these things to these people, or I told these people this or that. But that stuff will come out in discovery, which is why they're like desperate to dismiss this shit. So
right. Yeah, that's going to be very challenging to deny if there's just a clear, unless she like printed them off and brought them in a manila envelope in the middle of the night, and like there's no like way to trace it. I don't know how she's going to deny it, but anyway, I'll let you go back to the getting through this. Sorry.
Yeah, no problem. No problem. All right. Where are we at here? And I skim over some of the law stuff unless Omar's here because I'm not a lawyer, as you guys know. So let's see. It's Wait, what do you do?
Good question. Like a bunch of random things. So I went to school for business, and then I started my small business, and then I wasn't really like super satisfied with that. So then I studied botanical medicine.
Cool.
So I studied like herbalism and plants and things like that. And then just one thing led to another, and I just like doing like deep dive videos and stuff. So I just kind of like investigate things. Yeah.
Hey man, as long as you're passionate.
I actually recently went to New York, and I went to the movie theater that this premiere happened at. I tried to break into the room that Justin was touching, and they did not let me. Like I talked to the managers, I talked to everybody, like they wouldn't let me, but I was able to kind of stick my phone underneath just to see what the room looked like.
Oh, the basement,
because people were like, there's this creator on TikTok named Coco Moco.
I think I've heard that name before. Yeah,
so like some tea, we used to be friends, and then out of nowhere she blocked me, and then I messaged her and I was like, why did you block me? Like that was so, it just seems like strange, because I'm like, usually if I have a problem with someone, like we'll just talk to each other.
Yeah,
but that just seems dramatic to like block someone. And she's like, you're spreading all this misinformation. Like that movie theater, I've been to it, there isn't even a basement. Like, so ever this whole thing's a lie. And I was like, okay, let me figure it out. So when I went there, I was like, I may as well go to the movie theater. And there's 100%, it's a basement. Like you take the escalator down, and there's like a really dingy storage room, which is where he was. So, yeah.
That's basement enough for me, but you know, I was about to say maybe they just like dug a hole and then filled it back in.
Exactly. Like I think it meets the definition of a basement because it's in the ground. So
yeah, that's so crazy. All right, man. Let's move back into this a little bit. It's well settled under California law. One who takes a responsible part in a publication of defamatory material may be held liable for the publication. And they're citing some case law here. You guys know I skim over the case law if Omar's not here. So, as alleged in the FAC, Lively defamed the Wayfarer parties on her own behalf and through her agents, the Sloan parties, and Reynolds. And I guess Brian is listed as an agent here because wasn't he her representative in that meeting where they had to sign the 17-point document? Okay. All right. Indeed, the actual smear campaign was orchestrated by Sloan at Lively's direction. At all relevant times, the Sloan parties were engaged by Lively to serve as her public relations representatives and manage her dealings with the media. Lively and the Sloan parties stood in an agency relationship with Lively as a principal and the Sloan parties as her agents. At all relevant times, Reynolds, too, was in an agency relationship with Lively, representing her in dealings with WME and others, and acting as her, that answered my question, and acting as her representative in dealings with Wayfarer and Sony. The Sloan parties and Reynolds acted as Lively's henchmen I think that's kind of funny, just because also in the other filings from Lively, they were saying Jed Wallace was a hired gun. So now we both have henchmen. Okay.
Mhm.
In carrying out the vicious scheme to usurp the film franchise and destroy the Wayfarer parties, with the former leveraging media connections and the latter leveraging entertainment industry connections. As alleged,
Yeah.
Lively acted with and through them. Go ahead.
I do wonder if there's evidence for when they're using the word like usurp. It's kind of it's implying that there was an attempt to. I understand they tried to take over the film, but like I do wonder if there's going to be more information that comes out that there was an actual attempt to take over the franchise. Like if that was like the ultimate goal. Like, you know how there are rumors that there was some kind of clause that if there was like a morality breach that they could take the rights away from him.
Yeah, I mean, that's a great point. It certainly seems that way. I honestly had never really thought about it until like today or yesterday, because somebody had brought that up on Reddit, and they were on Omar's stream earlier today. And she had like a freaking, it was like 22 pages of like research she had done and just like outlining everything. It was like, oh my God, this is worse than I thought. Like, that's crazy. But yeah, no, totally. It seems that way. It definitely seems that way.
Well, they both have
go
production
ahead.
studios. Like Blake Lively started one called B for Effort, which is like actually like finally something self-aware in terms of how she named it. And like I think she, like, my own theory is that she wanted to be sort of like Reese Witherspoon, where she brings stories to life and whatever, but doesn't really know what to do because they've never released anything.
Yeah.
I mean, she admitted in an interview that she didn't know anything about Colleen Hoover. So I think it's very possible that she sort of saw this as like an opportunity, like, oh, the Colleen Hoover cinematic universe could be something that we take, right? Take advantage of this author and take all of her books, like all of these popular things, and turn them into films. That would be interesting because it would show that there was like a motivation behind them possibly trying to take over the film beyond just creative disputes. Like there was actually a long-term goal.
Yeah.
Which would be interesting.
That's wild.
But yeah, I mean, I think people also forget how successful the movie was. Like, in terms of the return on investment, the actual film itself was like, the budget was 20 million. It ended up making like 350 million, which is like a 12 times whatever return on investment. Whereas Deadpool only made a 6-time return. Like it was, like it was financially very, very successful. So
I didn't even realize that.
Yeah, like I could imagine them being like, oh, wow, there's a huge opportunity here to like take over the Colleen Hoover thing. But at that point, we have to get Justin Baldoni out of the way because maybe she'll want to give more of the rights to him. He owned the rights to It Ends With Us and It Starts With Us. That was it, though. So it's not like he owned everything, but still.
What's the last book in the series? I can't remember.
For It Ends With Us?
So there's It Ends With Us, It Starts With Us, and then there's one more, right?
Is there a third?
Yeah, there's a third one. Hang on.
It
Ends With Us series. Yeah, you and I both.
There doesn't need to be 3 books. Like, that's crazy.
There were, though. Oh, yeah. Okay.
It keeps going with us. Like, what did she name it?
Here it is. It Ends With Us. Nope, that's a different Colleen Hoover box set. But no, I really thought there was. It's so there's. It starts with us. Hang on. Third book. I could have sworn there was a third book, dude. Okay.
Yeah, I guess
no. Maybe I lied about that, man. I don't know. I didn't do it on purpose.
They're all the same. They're all the same. Like,
oh, will there be a book 3? Okay, that's where I got confused. I hope not. It Starts With Us felt rusty. Okay. Yeah, no. So I listened to, I think that where I got confused is I listened to this girl on YouTube, and I wish I could remember now who it was, because I listened to it way back when the movie first came out, because I was like, I haven't read the books. I want to know if this is worth it. I listened to her recap the books, and she did it in 3 parts. So gosh, if I can find the creator, guys, I'll pin it in the comments once the stream is over. But she did a really good job of recapping all that. Yeah,
it's the Lord's work. I read it. I read the first one just for like research purposes.
Damn.
I found it very problematic, but
yeah, I never read, like I said, I never read the book. I listened to the recaps. I watched the movie. I've actually watched the movie twice because I watched it by myself just to know what I was talking about here, and then I watched it with my sister because she wanted to watch it. but I
What'd you
know
think?
way more about this movie than I ever wanted to know. Yeah.
Did you like the movie?
It was okay.
Mm-hmm.
It was okay to me. I thought the rooftop scene, the infamous rooftop scene, was something that bothered me before I knew Ryan
Mm-hmm.
Reynolds ever wrote it. I was just kind of like, and apparently it echoed the book pretty well. So I would argue also with the book, then I guess, with like you're making the male character too creepy right off the bat. If you want to represent true DV relationships and stuff like that, you got to make
Mm-hmm.
him like very charming, very kind of polished and stuff like that. Saying I want to have sex with you, like that's not doing it for most women. Like not
Mm-hmm.
the most women like Lily Bloom. Let's put it that way, because you know some of us will, some of us will be fine with that. But at that point in her life, for Lily Bloom, who was very kind of, I felt at that point in the movie, shy-ish and timid, and like in as far as like physical touch and stuff like that, because she was kind of resistant at first to like getting too close to him. And that's just my interpretation. I felt like it didn't really do a great job of portraying how that would go and how she got deeper and deeper into that relationship. Because if I were her and I were in her situation and all that happened, I would just kind of try to disappear into the background and get this dude to leave me alone. I wouldn't like, you know? So I feel like he should have been more charming and less creepy and less way too forward. But
Mm-hmm.
that's just me. So.
Yeah, that is how he was in the book, to be
Mhm.
honest with you. Like in that scene in the book or chapter in the book, he was very forward and very creepy. There was a lot more red flags with him, to be honest, in the book than there was in the movie. Like he was creepy in the rooftop scene. And then other than that, I feel like he was portrayed as like very likable, whatever.
Yeah.
But the only part I don't even want to say I liked about the book, but worked about the book was that she was younger. Like she was like 23 and he was like closer to 30s.
Mm-hmm.
And it was written from her perspective, and she was very much like, oh yes, like Ryle, like I'm in love with you. Like she would talk about how she was like, basically so horny for him. You know?
That's what love is when you're in your early 20s, not
young.
necessarily when you're Blake Lively's age playing a young character.
Yeah, like it didn't work as well. And like even Colleen Hoover after was like, you know what? It didn't really make sense that I made the characters these ages in the book, because then in the book it's split up into like the book, and then there's her writing letters to Ellen DeGeneres, which is like was so stupid. Like that was instead of journal entries. Did you know that?
Nope.
Yeah. So half of the book, I literally have it like right there, is instead of journal entries from Lily Bloom, she wrote all of her journal entries to Ellen DeGeneres for some reason. It doesn't.
That is extremely fucking random.
Yeah, it's so random. So she's like,
well, let's put it this way. I don't write my. By the way, I don't write my middle school diary entries to Ellen DeGeneres. So why should Lily Bloom?
It was just like no explanation. Just it would be like, hey Ellen, like today I did this and today I did that. But then it was like the time jump was like, oh, like a 19-year-old to a 23-year-old. Like we don't need to see that.
Oh
So
man, no. Yeah, my diary entries were all to this lady named Michaela Gordon. She was a contestant, an unsuccessful contestant on American Idol when I was 10. And I never let her go, apparently, because I write to her a lot in my diary.
I had really weird obsessions with people on singing shows too, actually. Like, it was like really unhealthy.
Dude, wait, who's your favorite though? Wait, not who's your favorite. Who are you the most obsessed with? Let's put it that way.
Well, okay, mine was like the American Idol when it was like David Archuleta versus David Cook.
I love David Archuleta.
That was like the season where I was obsessed with like everybody, and there was this girl named Pia Toscano who was like eliminated really early, and I never got over it.
Oh no. Tears really flowing from both of us. Anyway, somebody says I would love to hear more about the filing, so maybe I should go back to reading.
Go back.
We're totally going to have this conversation behind the scenes another time. Okay, anyways. All right. So we went through, as alleged in the FAC, she defamed Wayfarer on her own behalf and through Sloan and Reynolds. Indeed, the actual smear campaign was orchestrated by Sloan at Lively's direction. At all relevant time, the Sloan parties were engaged by Lively to serve as her public relations representatives and manage her dealings with media. Lively and the Sloan parties stood in an agency relationship, with Lively as the principal and Sloan parties as her agents. At all relevant times, Reynolds, too, was in an agency relationship with Lively, representing her in dealings with WME and others, and acting as her representative in dealings with Wayfarer and Sony. The Sloan parties and Reynolds acted as Lively's henchmen, and we read that, I think, in carrying out the vicious scheme to usurp the film and destroy Wayfarer, with the former leveraging media connections and the latter leveraging entertainment industry connections, as alleged Lively acted with and through them. Under the principles of agency, Lively is liable for defamation by the Sloan parties and Reynolds. In California, a principal is liable to third parties for acts undertaken by her agents in the course of such agency that are wrongful in their nature. As used in California Civil Code 2343, acts are wrongful when they constitute an independent tort, such as defamation. The Sloan parties made defamatory statements as agents of Lively, their principal, squarely within the course and scope of their agency. Indeed, communicating with the press on Lively's behalf is exactly what they were hired to do. Thus, the Sloan parties acted with actual authority, or authority that the principal Lively intentionally conferred upon the agent Sloan, or intentionally or by want of ordinary care allowed Sloan to believe herself to possess. As the Sloan party's employer, Lively is also liable for their statements under the doctrine of respondeat superior. Under the doctrine of respondeat superior, an employer may be held liable for defamatory statement made by its employees. Okay, that makes sense. Respondeat superior liability is triggered if the defamation occurred within the scope of the employee's employment, even if the principal is not aware of the statement and the statement was not made for the benefit of the principal. Okay. Statements are made within the scope of employment if such statements are those that may fairly be regarded as typical or broadly incidental to the enterprise undertaken by the employer. Okay. There's a footnote here that I missed. Let's see where footnote 2 is. I don't see it on this page. We're just going to read the footnote then. Given the degree of control Lively is alleged to have exercised over the Sloan parties, they clearly stand in an employment relationship under California law, regardless of how the engagement was styled. Okay. And they're citing a case here. It says the essential characteristic of an employment relationship is the right to control and direct the activities of the person rendering the service, or the manner and method in which the work is performed. Okay. In addition, the determination of employment status is a question of fact. Okay. Let's see what else we got here. We're going to skim over this case law stuff. As alleged in the FAC, the Sloan parties made a series of defamatory statements about the Wayfarer parties within the scope of their employment/agency. As to Baldoni, the FAC alleges that the Sloan parties made statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. Now, okay, let me finish this paragraph before I go off on my tangent. The Sloan parties also made other false statements in response to the media inquiries concerning Lively's wrongful accumulation of power over the production, the means by which she did so, and the resulting turmoil. Okay. So with that, God, I'm just thinking back to like everything that he was accused of, and how there's all these hoops they have to jump through to like get justice for that. I think that if you falsely accuse someone of sexual harassment and stuff like this, or like whatever they're saying she accused him of, which is a lot, and calling him a sexual predator, like they say here, I think the punishment should be way more severe than it apparently is. I think it should be way less stringent of a standard to like enact that punishment. Like if you call someone a sexual predator, you should have to prove that with facts. Like especially if you're a powerful Hollywood figure. If you're just like a rando person having a schizophrenic episode, that's different because that's not the same. Right? But if you're a powerful person like Ryan Reynolds and Blake Lively, who together with their collective, full knowing consciousness, accuse this man who has been nothing but an ally to women, of being a sexual predator against women. Like, I feel like you should face consequences of that, and it should be a way easier thing to get justice for, if that makes sense.
100%. Yeah.
Yeah.
I don't know
And I
even
never
if
really, yeah.
California law or if it's New York or like,
Yeah.
that's not been determined yet, right?
No, I don't think so. To my knowledge, it has not.
Yeah.
I'm a little confused by that when it comes to the jurisdiction stuff, but yeah.
It is confusing. And like you said, like it's one public figure speaking about another public figure. So I understand if it's a random person, it's hard to prove a defamation case,
Yeah.
or even just a small content creator talking about a huge celebrity. Okay. But you're both like, I mean, they're more prominent than him, which honestly makes it worse because collectively they have like hundreds of millions of fans. And like the burden should be on you if you're going to prove that he's a sexual predator. And at this point, I don't even know. Like this is one of the things I'm confused about is, can we even point to one instance that's like everyone can kind of agree is like clear sexual harassment, where it's like Taylor Swift sued that guy because he put his hand up her skirt, and rightfully so. Like that's a very clear, terrible example of like clear sexual harassment. Done, was found guilty. Like, can someone even tell me now where it's like, I feel like a lot of this has become very amorphous, where it's like, he looked at me the wrong way. One of the accusations, I don't know if you caught it in one of her amended complaint, was that he took photos of her secretly. And I'm like, why would he need to take photos of you if he had all this footage of you, if he was some creep?
No, that's so crazy, dude.
What is it? And interestingly, she even accused previously like a makeup artist of secretly taking a photo of her when she was sleeping and got him fired. And I tried to track down who that was, and I wasn't able to. But I'm just like, do you know, like, is there one instance of sexual harassment that we can like point to?
Not that I'm aware of. I mean, the closest thing I could have thought of in the beginning of all this was the showing of the like. They claimed it was like a nude person giving birth or whatever, which was not the case at all. You couldn't see any body parts really. It was a very far away image of Jamey Heath's wife giving birth at a home birth, like, and it was for a specific purpose in the film. So it's not like, I don't think so. I don't think so. It was the only thing that comes to mind.
It was in the context of, you can take anything out of context. Like it's in the context of filming a birthing scene. And it's weird because it's like, who's sexualizing birth? Like no one's, I mean, to my knowledge, maybe there's some weird people out there, but no one's like looking at images of women giving birth being like, oh yeah, that's like a sexual thing. Or same with breastfeeding. It's like, I think that was even the disconnect where like when Justin Baldoni in that one voice was like, you probably have a baby on your boob. Like a lot of people thought that was weird.
Yeah.
And I asked my mom about it. I was like, do you feel like that's weird? She's like, I don't really think it's weird. Like women breastfeed. Like some people are more comfortable talking about that. And if that's the standard of language that was set, which it seems like it was, like just like Ryan Reynolds and Blake Lively are very comfortable being very, like their humor is very crude and very sexual. So it's not like they're like these innocent like Mennonites who are like, we can't talk about that. Like, they were, like we were setting the parameters for it. So it's just, this whole thing is just a disaster, honestly.
Yeah, man. I mean, and he has a wife and children, so it's also like, of course, he's seen people breastfeed before, so he knows, you know, like there's a baby on your boob right now because my wife went through the same thing. It's not the same. And also, like after he said that, you wouldn't then be like, "Hey, want to get on a plane with us? Go back to California?" Like that's just ridiculous.
Exactly.
So crazy.
Nothing about it.
Blake had a boob cake made for her kid's birthday. Nobody ever made me a boob cake. What the hell? So
Didn't she say something like it was either going to be a boob cake or a penis cake or something? It was like really weird.
Yeah, I can't remember exactly what you're talking about. It sounds familiar though. All right. Some people say it's because Heath is black. I mean, honestly, maybe. I don't know.
I think it's possible. A few people have like brought that up where it's like you're trying to like, things are being characterized in a way that's not adding up. And it's like with their history, I don't know. I'm not the one that can be like the juror of that, but
it's
for sure.
I mean, I'm also hesitant to say like outright, like, yes, totally, she's racist. You know what I mean? But like at the same time, it's like this is clearly there's something going on here. So I'm gonna keep my mind open to that.
Yeah, at the very least, like
Yeah.
like someone actually who was at their wedding sent me photos of their
Oh
wedding.
shit.
I did it in one of the videos, or I didn't include that exact photo because I didn't want that person to get in trouble. But basically, her daughter had performed at their wedding because there was like a choir, and like you can see the photos of their backyard, like where that plantation was, like the cells, like from where the venue is, where the vows are said. Like you can literally see all of the cells where the slaves were kept.
Oh shit.
It's
Wow.
like who, and I don't know if you know this, I even called the venue pretending to be like that I had a client who wanted to have a wedding there because I wanted to see like, oh, could there be any like doubt that this wasn't like a real plantation or like there was some miscommunication? And it was like the lady was so clear. She was like, this is 100% a historical plantation first and a wedding venue second. And there was like absolutely no, like, she's like, I want to be very clear about that. There's lots of signs. This is like a historical thing and it's like going to be everywhere basically. She's like, just make sure that the bride knows that like this is going to be everywhere and it's going to be like a prominent part of the wedding if she's comfortable with that. So it's like, I don't know, getting married there, definitely very bizarre.
There's so many little things like that that I just like I'm not yet up to speed on because I've been so busy with other shit, you know what I mean? But like, wow, holy crap, that's so crazy. All right, let's see. I'll read the rest of this page at least. Let's see. As alleged in the FAC, the Sloan parties made a series of defamatory statements about the Wayfarer parties within the scope of their employment/agency. As to Baldoni, the FAC alleges that the Sloan parties made statements to third parties, including without limitation to the NYT and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. The Sloan parties also made other false statements in response to media inquiries concerning Lively's wrongful accumulation of power over the production, the means by which she did so, for example, false accusations of sexual misconduct, and the resulting turmoil. Although not in an employment relationship, Reynolds, too, was acting as Lively's agent when he defamed the Wayfarer parties. As alleged on at least 2 occasions, Reynolds stated to executives at WME, Baldoni and Wayfarer's talent agency, that Baldoni is a sexual predator. And they're citing the FAC here. Reynolds knew, as the jury will know, that an accusation of this kind renders the target persona non grata by referring to Baldoni. What's that?
Unless you're PDA. Because they're still working with him.
Oh, we got 2 people in here with us. We got Omar, my lawyer friend who was with us earlier, and then also Bruce from Oregon, my buddy who streams with me a lot. What's
Ladies
going on,
and
guys?
gentlemen.
Yeah.
Hello, friends.
Hello.
I don't know if Omar can actually hear us again. He might be with his children, but if not, I'll just kick him out again. It's fine. All right. Let me zoom back out a little bit. Bruce, have you been following along at all?
I have not.
Okay, so we're here on top of page 18. We're talking about what's the argument here? It's a very long one. It says Lively is liable for statements made by the Sloan parties under the principles of agency. Okay, and we're talking about Reynolds' involvement and all that stuff. We only got to the bottom of here.
It's the argument against 47.1.
Oh my God, you are here, Omar. Okay.
Totally. I'm totally here.
Yes.
I have not caught any of what you've read, though.
Guys, this is my new friend, Be Better. He's a really awesome influencer on TikTok, and we connected before, but this is the first time we streamed together. So,
it's a pleasure to meet you.
Mm-hmm. Yeah, these are my other friends. They're also totally normal. So, anyways, I'm going to read a little bit more of this, and then we'll stop for a second. Reynolds attempted to render untenable any continued ties between WME and Baldoni with the Sloan parties, who made similar defamatory statements to the press. Reynolds was part of the campaign to destroy Baldoni's reputation and career. As to the other Wayfarer parties, the FAC alleges that Lively and or her agents or co-conspirators made statements to third parties, including the New York Times and other outlets, to the effect that the Wayfarer parties engaged in, permitted, and or failed to prevent sexually inappropriate conduct towards Lively and others, and retaliated against Lively for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. As alleged, Lively and the others told the NYT a false and damning story about an insidious PR sabotage operation. Baby, you did that to yourself. Anyways, deployed as revenge for sexual harassment complaints with the knowledge and intent that the newspaper would publish the false story. All right. It says the Sloan parties propounded a false smear campaign narrative designed to destroy the Wayfarer parties. For the purposes of this motion, the bottom line is that the FAC alleges that Lively orchestrated, participated in, and directed her agents to carry out a defamation campaign designed to ruin the reputations and careers of the Wayfarer parties. Construing the allegations in the FAC as true, there is sufficient evidence that Lively took a responsible part in publishing each of the allegedly defamatory statements by approving or authorizing them prior to publication. Dickinson v. Cosby is what they're saying. Okay, cool. Although the Wayfarer parties submit that Lively personally approved or authorized the defamatory
Is that
statements.
Janice Dickinson?
What's that?
Janice Dickinson?
Dude, I don't know.
Cosby
Dickinson.
versus Dickinson. Is that like a civil SA case from like 10 years ago?
It must be, man.
I cannot read the screen, so I can't even cite it. Doesn't
It says
matter.
2019.
Oh, there it is. Yeah. Okay. Well, that's not as long as
5
ago,
years ago.
long ago as we thought, I think. Okay. Lively's liable regardless because she ratified them after the fact. In California, ratification is well-established doctrine for assigning vicarious liability to a principal for torts, even where those torts outside of the scope of the agency relationship. Okay. I'm going to skim over some of this stuff. Ratification in the voluntary election by a person to adopt in some manner as her own an act which was reportedly done on her behalf by another person, the effect of which is to treat the act as if originally authorized by her. So they're talking about like whether or not she's responsible for like her husband, I guess, or somebody else saying something. That's what I'm getting here?
Well, they're just saying that she is directing all of these people, and therefore she's vicariously liable through agency for all of these things. And they're continuing on. This is all stuff that we already knew, though. Like, what's the argument against 47-1?
We're still moving along in this document, so I'm not sure.
Oh,
But if
we
you
haven't
want to
gotten
find
there yet.
out, hang on. I need a favor, Bruce. Can you read that?
Can you make it larger?
Yes. I'll make it larger. And
Is that
are you
possible?
able to read that? I'll be right back. I have to go to the bathroom real quick.
If you can make it bigger. Where are we at?
We are at the top of this page. So right here where it says
Ooh.
follows
she
the lively
asked.
new statements.
Yeah. As long as you can scroll while you're going. I don't know.
Oh, I don't know. I'll do my best to go fast.
Otherwise, I'll get to
How
the
about that?
bottom of the page.
Yes.
Okay.
Okay. I'll be
And this
right back. I'm sorry,
follows-
guys.
It follows the lively new the statements of the Sloan parties and Reynolds, which stated the opposite, contained falsehoods. And then we've got Dickinson, 37. Okay. Given that the Sloan parties were Lively's public relations representatives and Reynolds, her husband, business partner, and designated representative, it is reasonable to infer, and the FAC alleges, that they were speaking on her behalf or with her authorization. Not only did Lively not immediately terminate the agency relationships or retract or clarify their statements, she doubled and tripled down, ratifying them and making them her own. What do you think about that, Omar? Maybe we've heard that
Sorry.
before.
My daughter was pulling at my leg.
Yeah. Okay.
Not only did Lively not immediately terminate the agency relationship. Oh,
Mhm.
well, yeah. I mean, but did they have to, though? I mean, I understand what they're trying to say,
Mhm.
but was that like a legal requirement for her to do something like that?
Mm. Okay.
And if they're trying to draw inferences from the complaint, I mean, this is going to end up with they're going to be able to amend their complaints. It's not going to be. They're not going to grant the motion dismiss. It's going to end up. They're going to have to amend the pleading somehow. They're trying to make inferences through what was pled. It should be obvious to everybody that through agency and vicarious liability and the fact that she never stopped them from doing what they were doing, therefore she's somehow guilty, even if she didn't have knowledge exactly of what they were doing.
So the default you're saying is that she would have had to do something to stop those statements from being associated with her.
So and she directs the PR agency and whoever else was involved to do the smear campaign or, whatever. She knows that it's going on. She directs them to do it without knowing specifically how they're going to do it. And she never at any point stops the plan. It's essentially what they're saying.
I see. All right, next paragraph. In such circumstances, the effect is as if Lively had approved or authorized the statements at the time the Sloan parties and Reynolds made them. Restatement, third of agency, section 7.03, quote, a principal is subject to direct liability to a third party harmed by an agent's conduct when the principal ratifies the agent's conduct, unquote. Further, in addition to authorizing an agent's otherwise unauthorized act, ratification may result in the creation of an agency relationship where none previously existed. See Rakestraw. Finally, as previously discussed, Lively engaged in confirmatory conduct, which suggests ratification. Such confirmatory conduct is not necessary, however, because a principal may ratify acts through conduct inconsistent with disapproval. Gates v. Bank of America, 1953. Wow. Good golly. Were they still called Bank of America back then? I guess. Let's see. Then we got section B, and I don't know if Lauren can scroll or not. Lively made defamatory statements herself. Ooh. Separate and apart from the actions of her agents, Lively made defamatory statements about the Wayfarer parties in her individual capacity. Specifically, the FAC alleges that Lively told the New York Times that the Wayfarer parties engaged in, permitted, and or failed to prevent sexual misconduct and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure thereof. And then they cite the FAC. Lively also falsely claimed to the New York Times that the Wayfarer party's agreement to the 17-point letter was proof positive that sexual harassment was endemic on the film's set. Oh dear. FAC, paragraph 270. And that the Wayfarer parties had responded. Okay, we're at the bottom of the page here, Lauren.
1 second.
You doing all right?
Yep, I just got back. Sorry.
No worries. Where were we here?
You can just finish the paragraph at the top here, and I'll.
Lively's complaints about purported sexual harassment by plotting to destroy her reputation. FAC, paragraph 272. In short, Lively told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish that false story. The fabrications made by Lively are further detailed below and exhaustively outlined in the FAC. Oh no.
Omar,
Good time.
you want to mute your children?
I thought I was muted.
Anyways,
never mind them.
I will take over here. 2, the Wayfarer party's defamation claim is timely. Lively's statute of limitation argument is meritless. Specifically, Lively contends that the defamation claim is time barred under California and New York law by a 1-year statute of limitations. Although Lively implausibly argues that the defamation claim arises from the 17-point list presented to Wayfarer in or around November 2023, that is wrong. Although certain of the Wayfarer party's claims implicate the 17-point list and Lively's conduct during production, the defamation claim arises from statements made between July 2024 and December 2024. The instant action is therefore timely. Okay. 3, the defamatory statements are not privileged. Lively also argues that the Wayfarer party's defamation claim fails because the statements at issue are protected by 3 overlapping privileges. 1, the litigation privilege. 2, the so-called sexual harassment privilege. And the fair reporting privilege. All right. But as detailed below, none of the 3 privileges insulate Lively, not only as a legal matter, but as a factual one as well. Okay. This is all case law stuff, so I'm going to skim over that. The litigation privilege does not apply. The litigation privilege, codified in California Civil Code 47B, provides that a publication or broadcast made as part of a judicial proceeding is privileged. The privilege applies to any communication, 1, made in judicial or quasi-judicial proceedings, 2, by litigants or other participants authorized by law, 3, to achieve the objects of the litigation, and 4, that have some connection or logical relation to the action. All right. The principal purpose of the litigation privilege is to afford litigants and witnesses the utmost freedom of access to the courts without fear of being harassed subsequently by derivative tort actions. A communication protected by the privilege must be in furtherance of the objects of the litigation. The communication must be connected with or have some logical relation to the action. Okay. Lively's litigation privilege argument is predicated on the false premise that these statements at issue were made in legal pleadings or as part of the legal proceeding. But that is simply not the case. The Wayfarer party's defamation claim against Lively arises from her statements and those of her agents to the media, WME executives, and others from July to December 2024. The FAC does not seek to hold Lively liable for even otherwise defamatory statements actually made in the CRD complaint or lawsuit. For the litigation privilege to apply, the logical relation between the communicative act and litigation must be a functional connection. Let me just
Can
make
we
sure.
pause?
Yeah. Go ahead.
You're glossing over really important stuff.
Well, duh, I'm not a lawyer, mister.
So they're making a couple of different points and kind of hinting at their strategy.
Mm-hmm.
The statute of limitations thing, they're saying didn't start in December. It started in January. When I addressed their 12B6 motion, the way that I had got around that is it doesn't really begin until it actually becomes defamatory or you have knowledge that it becomes defamatory. It was authored in December. It became defamatory. They're arguing in January, and therefore they're within the statute of limitations. That's point number one.
What
And
was
then
the
point number
triggering
two
event
is-
in January?
I don't know, but they're arguing it. I would have argued it was something different. But what they're also stating is that even if that wasn't the triggering, I don't know what they're saying is triggering it to start in January, but they're also stating that she made defamatory statements to the Times, who then ran with and published those defamatory statements, regardless of whether or not they knew they were defamatory when they published it. That's the New York Times issue. Lively, by letting those statements go to the Times, when the Times published it, that attributes those statements directly to her through agency, vicarious liability, and all the other things they had just started. And so they're well within. The statute of limitations is not going to be an issue in this lawsuit. And it was also interesting just because their version of when they feel the defamation was triggered, they're not stating that, look, we were aware of this letter in December. There was a period of time where at some point it was just talks. And then there was a definitive point in time where it became defamatory when she published it to those in the know. I guess that would have been the triggering event. I just don't know what that would have been in January.
Yeah.
But all that to state, statute of limitations is not going to be a thing in this case.
And not only the specific point in time, but it seems like they're arguing it was all happening outside of court documentation, right? Which is important, right? Because otherwise there would be privileges related to an in-court procedure, correct?
Yeah, whatever was reported in the Times is not the defamatory statements. I mean, those statements were made well before it was ever published in any kind of litigation. So that's kind of the Times defense, is that the Times has the litigation privilege, I think. If that's the statements that they're attributing as defamatory, and the Times have already raised that defense. They also raised the journalist privilege or whatever it's called. I forget what it's called. But she made those statements.
Fair
not in the
report
context
privilege,
of,
I think.
yeah,
Fair
fair
report,
reporting.
yeah.
Fair reporting, yeah.
She made those statements not in the context of any litigation. She just threw those out to the press, and they didn't run with them until she actually filed her CRD. And then the timing of all of that suggests, according to Friedman and his attorneys, a conspiracy to defame. So we're kind of starting to see the pieces of the puzzle come together about their theory of the case. It was just, I didn't just want to gloss over that. That was actually really important. I'm gonna have to go back and read that again.
Yeah, the timeline in this case is very critical.
I always forget when I've muted myself. I was going to say, when you do read back over it, if you need any help with clownage, I'll be there. All right. Let's see. For the litigation privilege to apply, the logical relation between the communicative act and the litigation must be a functional connection. This has been interpreted by California courts to mean that the communication must function as a necessary or useful step in the litigation process and must serve its purposes. Thus, while such acts as filing a lawsuit or, in many cases, sending a demand letter, is that like a cease and desist or something?
No, it's a demand letter.
What does that mean? I don't know what that means.
I demand of you to do something. A cease and desist
I
means.
could send you a demand letter. It doesn't mean anything.
Well, yeah. I mean, anybody could send a demand letter, but a cease and desist is different. It's like, look, you're doing something, stop it or else I'm going to sue. A demand letter doesn't have those. Exactly.
I think the question is, does a demand letter have a specific legal definition, or is it just sort of colloquial?
No. Yeah, it's colloquial. There's not like a clear-cut definition. Just, it's a letter with a demand in it, really.
Let's see. Anybody here, Bruce, Omar, or Be Better, have any of you ever received a demand letter?
Of course I have. I write them all the time.
Oh, but
I
not in
receive
your
them all the
job.
time.
I mean, like in your personal life.
Oh, I'm sure at some point in my 44 years, I must have received one or two.
I've only received cease and desists. I don't know if it's like an umbrella term, and that's like a demand because it's demanding that I stop talking.
Did you stop talking?
No.
Good. Okay. All right, sweet.
I feel like a cease and desist would be a specific subset of a demand letter, maybe.
That's what I would imagine.
Yeah.
No, though.
Oh, I have to work harder. I've never received one yet, but I've been threatened with one, but I was just like, you're threatening me to threaten me with a threat. Like, what does that mean? What does that mean, dude? Oh my gosh. All right. Let's see. Where are we at here? This has been interpreted by California courts, blah, blah, blah. Thus, while such acts as filing a lawsuit, sending a demand letter are protected, communicating with the public or press is not, even when it advances litigation by rallying the masses. Indeed, what if the masses are already rallying behind you without your prompt? Indeed, the litigation privilege does not protect litigating in the press. Such an extension, and I'm assuming they're again applying this in the New York Times, such an extension would not serve the purposes of the privilege. Indeed, it would serve no purpose but to provide immunity to those who would inflict upon our system of justice the damage which litigating in the press generally causes. Poisoning of jury pools and bringing disrepute upon the judiciary and the bar. Okay. Here we have a case they're citing that says, for example, the court observed the defendant's online posts, while related to an ongoing proceeding, were mere unprotected public denunciations of the plaintiff. Huh. Okay. Furthermore, even though certain pre-litigation activity is protected by the litigation privilege, albeit not Lively's, such protections only apply when litigation is seriously considered. All right. While Lively is likely to point to her now pending lawsuit in response, the Wayfarer parties allege and maintain that Lively never intended to file a civil lawsuit, which would have triggered the Wayfarer parties' right to discovery. Okay. That makes sense.
I believe that.
Yeah. No, for real, though.
Yeah.
Lively.
I just went over, Lauren, we just went over a whole theory that basically explains, corroborates what Anita was saying.
Yeah, right.
That falls right into that theory. God, I got to go back and listen to that again. She basically said that, look, they were never going to file a lawsuit because filing a lawsuit was going to lead to them being subject to discovery.
Yeah.
Yeah.
Anyway, never mind. I didn't mean to interrupt.
What, so she got her Reddit post deleted. Why was that again?
Well, we have no idea, but she put that out there, and then just stuff like her account just started getting attacked. Like posts were getting deleted, and she had to repost things, and it was like this big deal. I have no idea what that's about. It could be nothing. It could be something nefarious.
Yeah,
it was just an interesting side note.
I don't know if Bruce or Be Better saw that by any chance earlier, but it was like a 22-page document she did of like very
Well,
elaborate research, and apparently it was like removed from Reddit and shit like that. So
I mean,
And originally it
we
was
know
only
from the Owens v. Eckerd case that on Reddit, the mods have to be very careful about what they allow in
that's
these
true.
subs, because they can have the whole subreddit shut
Mhm.
down if there's something in there that is too, is too
Mhm.
much
Hmm.
for the corporate Reddit people to allow to be on there. So this is why multiple subreddits in the Owens v. Eckerd case were there, removed, there,
Yeah,
removed.
that's true.
But this is very interesting, and speaking of the Owens v. Eckerd case, she probably should have thought about how this paternity case was going to open her up to discovery too. It's the same thing.
Hmm.
Yeah.
What was the gist of the post? Do you know?
Omar, you probably explain that best.
Well, I was just going over the timeline. It outlined kind of the threads of their conspiracy, what they're planning to do, how she thinks that it was Lively's intention to try to steal the movie rights away from Baldoni because she wanted to turn it into a franchise, and then how inch by inch she continues to kind of increasingly push him out. And then she lodges this 17-page thing. She's never intending to file a lawsuit. It turns out she catches wind that they were maybe gearing up to sue her for what they believed, well, what they were preparing for was going to be a smear campaign against them, because they caught wind of text messages back and forth between Sloan and the PR company and the New York Times and whatever that they were doing to Justin. And so preemptively, rather than wait for that hammer to drop, she decides to file this CRD complaint in December to kind of get ahead of it. And then everything else is retaliation after that. But she never intended to file this lawsuit. And then the question was, why did she file this when this was the evidence? And the answer was, she never thought that Justin was going to hire Brian Friedman and that he was going to come after her the way that she's being gone after, because now she's in trouble. She thought they were going to bully Justin into submission, and they were going to settle all this. It would have never seen the light of day. Instead, what they did was start the highest profile celebrity lawsuit of this century.
Right.
Well, I know that Jamie and even Steve Starowitz, I think, they both share the same kind of principles of the Baha'i with Justin, as far as like not talking bad about anybody. And I think they avoid, like having conflicts like this. But I wonder if other people involved with It Ends With Us LLC and Wayfarer Studios pressured them into like, hey, we have to, take action against this. We can't just like sit here and take it on the chin, because Justin does seem very much like somebody who's like passive and is like not wanting to speak ill of anyone ever, and like does not want to fight with people. And it
makes sense. He would
sucks that
roll
people,
over.
it seems like people take advantage of people like that, and it sucks because it's like there should be more people like that in the world, but there's not, because anyone like Blake will take the opportunity to fuck up your life.
And that was her experience with him, ultimately. So it would make sense that she would assume that he wasn't going to fight back. Based on that, she also was either married to or dated Penn Badji, who's also Baha'i, very passive.
Oh, that's right.
Right? Like, that could be part of it. Also, her PR team is very much old school. Like, had this happened in 2017 during the Me Too movement, like the height of it, where just a simple accusation was a death sentence, that probably would have been it. CRD complaint, New York Times story. People don't really know how to distinguish between the CRD complaint and actual lawsuit anyway. They probably just thought that's all that was going to happen. And then that was the grave miscalculation, I think.
Yeah. Man, I mean, this is going to be, I feel like this is going to keep going. I mean, the trial's not for another year, assuming they go to trial, which I think they will. And I think everyone here probably thinks they will, right?
I think they're going to trial.
Yeah, I think they are too.
I'm less skeptical of a settlement.
Oh, really?
Yeah,
I don't see either party conceding to any kind of settlement, because the other side will not agree to an apology.
I think Lively will agree to a settlement. I don't think Friedman is of settlement mind right now. I see no evidence that he's entertaining any settlement discussions right now.
I don't think Ryan and Blake would agree to a settlement, because I don't think Ryan and Blake could take the hit to their reputation and keep up their lifestyle at this point.
Omar, I feel like a few weeks ago, our sort of consensus was that a settlement was most likely. But based on these
Yeah.
latest court documents and interviews with Brian Friedman, you've changed your mind?
I've just based it on the way that they're attacking this. Like, there's
Yeah.
obvious things that they could do to try to file their own 12B6 motion against Lively's complaint, and they just are not doing it. And I think doing it specifically because they want to beat her up in deposition, cross-examination. They want to take her to trial and have her litigate the entire thing. But like, they're going for a major judgment here. Like, they don't want to let her off the hook. There's nothing
Yeah.
about Brian Friedman's conduct in this litigation that screams, you know what? Yeah, we're open to settlement talks. He hasn't, and he has the ability to do this. He hasn't even filed a motion to dismiss her SH claims or whittle down her complaint. None of the things that they're trying to do that everybody else is doing has Friedman done with respect to Lively. He's willing to no, I'm not dismissing anything. Let it stand. Because now I'm going to cross-examine her and attack her on all of these other issues, and she's going to look really bad in court. And this case isn't even really about sexual harassment. It's about breach of contract. If he can prove that she was full of shit on the sexual harassment stuff, then all the other stuff is going to fall in the line, and it just becomes this huge red flag in Lively's credibility that he's going to highlight for a jury, and he's going to ride it all the way to a $500 million judgment.
Mm-hmm. So
Well,
he's leaving it all up there to have maximum foundation, is what you're saying.
Sexual harassment is,
and then,
like,
in other words, getting rid of.
Go ahead, Omar.
If you get rid of the sexual harassment aspect of the case, you're just depleting half your ammo. Why would you do that when it's in your favor?
If there was not a sexual harassment aspect of the case, it'd be like, who would care? You know what I mean? Because like, if it's like contractual stuff like that, like you might get like an article from media every now and then, but like if there's no sexual harassment, it's like, who really gives a shit about contract stuff that much, except for people who are really invested? So they had to put in sexual harassment. They had to kind of misinterpret and misrepresent his behavior and stuff like that, and say, hey, this was sexual harassment, to get people to give a shit, in my opinion, because she was trying to fix her reputation when she destroyed it by like doing a terrible job on her press tour. So
they had no idea what was coming. And even Ask Two lawyers have said that, look, I feel like at some point they're going to settle. They're going to try to maybe dismiss their defamation claim in exchange for dismissing the SH stuff because of 47.1 and the punitive measures that would take hold if he fails at his defamation complaint. And but I get that, but I also see Friedman, and I don't think that he's scared of 47.1. He's shown nothing to suggest he's afraid of that. Now, he might be. But then I don't see any 12B6 motions. I don't see any motions to whittle down her complaint. I don't see him doing anything to get rid of it, let alone get rid of his defamation claim against her. And so I'm just reading the tea leaves. This smelled a lot like a trial, man.
Yeah.
Is it possible he's playing chicken with their legal team a little bit?
That's always possible, but I guess I can't discount that fact. But the way that he's been talking and the way that he was so quick, look, you know how it is so unusual for an attorney to just drop a 168-page document of evidence and publish it for the world to see before anything ever gets going, like at the pleading stage, really. He's so confident in the evidence in this case. He thinks that he's going to be able to prove a lot of things. And he's alluded to in some of these oppositions that he's got even more evidence, and just wait and see. It's possible that he's playing chicken, but I think it looks a lot more like, oh, they don't even know what's coming. I got all of this stuff and they got nothing, and they know they got nothing. I'm going to bring this in front of a jury. Jurors are going to be the ones that decide this case, and this is going to be the biggest win of I don't know if it was of his career, but it's going to be a huge win.
Wow.
If he is allowed to beat her up on these SH charges when the jury sees how ridiculous they are, and how it only makes sense that you would bring allegations that ridiculous if it's in conjunction with malicious defamatory statements, all in a conspiracy to overtake Baldoni in the production of the film for control of the movie, because she wanted to start a movie franchise, because she wanted to erase him from the industry. It's all going to tie together perfectly, and I smell a huge jury award, and I think Friedman does too.
Wow. But what's the logistics of that? Like, if they really were to win like $500 million, like, they just have to sell all their assets and give it to them. Like I'm trying to like that's just crazy.
Yeah, I mean, they're going to be collecting on that. I don't know if they're going to have the ability to pay it outright, but they'll be collecting on it. They got 20 years to collect. Now, I don't know how it's going to be. I mean, it's a federal lawsuit, and so the federal rules would apply, but they're going to be collecting on the whatever civil judgment there is for years. I'd imagine that they probably, after the fact, try to settle it, to whittle it down, to make it more manageable, maybe give them money up front so that they're not having to pay $500 million. I'd imagine that they're going to try everything they can not to pay it right away and drag out that litigation for years. And then it's not going to be about this case. It's going to be about how much of the judgment they're actually going to be forced to pay. It's going to be a mess. In other words, there's not a chance that they're going to get the entire amount. It's going to be like a whole other litigation involving how to collect this judgment that they've just won.
Wow.
It's going to get messy.
Mm-hmm.
Can I ask
Anyway,
what?
folks, I got to put my kids to bed. I'll be right back.
Unacceptable, but okay. Yeah.
Well, okay.
All right. All right. Well, he's gone. We'll read some more stuff, I guess. Oh my God. Hang on 1 second. Okay, we're good. I saw another doc alert and I was like, what else is there? Okay, anyways. Furthermore, even though what's that? No, it's the same one. It's just they keep putting it on the docket for. So there's Lively versus Wayfarer, and there's Wayfarer versus Lively. So they sometimes update them separately. So it's the same document, just different notifications. Furthermore, even though certain pre-litigation activity is protected by the litigation privilege, albeit not Lively's, such protections only apply when litigation is seriously considered. While Lively is likely to point to her now pending lawsuit in response, the Wayfarer parties allege and maintain that Lively never intended to file a civil lawsuit, which would have triggered the Wayfarer parties' right to discovery. Lively did not ask the CRD to investigate Wayfarer. She requested a right to sue and then did not sue for weeks. Well, she had to let Megan Twohey get all that information first. As alleged in the FAC, Lively's pre-litigation communications therefore did not relate to litigation that was being contemplated in good faith. All right. And although Lively may contest the Wayfarer party's assertion whether a pre-litigation communication relates to litigation that is contemplated in good faith and under serious consideration is an issue of fact. Thus, Lively's litigation privilege argument cannot be considered on this motion. 5, the sexual harassment privilege does not apply, and this is actually, I think, what Omar was asking about, so we're going to have to talk to him about it when he gets back. Let's see here. Section 47.1 of the California Civil Code, or what Lively calls the sexual harassment privilege, protects a communication made by an individual without malice regarding an incident of sexual assault, harassment, or discrimination. A, Lively's defamatory statements were made with malice and without a reasonable basis in fact. Okay. What on earth? Oh my goodness. There's a whole, oh God.
This is the part we wanted to see, right?
No, yes, but I was looking at that message about the Reality Steve thing that's coming.
Breaking news, guys.
I don't even want to see that. All right. As stated above, anyways, not related to this case. This is something else. As stated above, Civil Code Section 47.1 applies only to communications made without malice. California Civil Code 47.1a, subsection C, as if there aren't enough subsections, further provides that this section shall only apply to individual that has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination. No, case closed. All right. No, just kidding. Those requirements that the communications be made without malice and with a reasonable basis in fact are why Lively's arguments fall flat. As alleged in the FAC, Lively fabricated her allegations of sexual harassment either wholesale or by exaggerating benign and not harassing interactions in a concerted malicious effort to seize control of the film and later to restore her reputation after a well-publicized series of marketing missteps that sullied her reputation. Specifically, Lively was hired to play the lead role of Lily Bloom. As part of the subsequent negotiations, Lively was granted an executive producer credit, a ceremonial title often given to talent of Lively's stature. Okay. However, Wayfarer and Sony refused to agree to give Lively a true producer credit because such a title would not accurately reflect the role she was asked to play. Wayfarer did not request or require that Lively contribute to the film in any capacity beyond her roles as an actor and executive producer. Although at the beginning of the production, it appeared that Lively and Baldoni would have a positive, collaborative, creative partnership, Lively had other intentions. In an interview with Forbes in 2022, 3 months before she was cast as Lily, Lively admitted, although not to Wayfarer or Sony, that she needs to have authorship in order to feel fulfilled, which producers and directors often perceive as a rug pull because they hired her to be an actress.
And we've reviewed that interview before, right?
Yep,
I
pretty
think I remember
recently,
that one.
within the last month or so. And it has the Forbes Power Women's Summit there, which is
Right.
where she is the quote, "When I showed up on set, I knew that they just wanted me to show up and look cute and stand on a little pink sticker where I'm supposed to go. Well, then don't audition to be just an actress. I mean, what the hell?"
Is
And
that the first
sometimes
time this interview made it to a filing? I think it might be. I don't know.
I think it's the first time in a filing, yes. I
Mhm.
mean, we've seen it circulating around the internet, but I
Sure.
haven't seen it, in this. And sometimes I would have people who really resented that because they were like, "We just hired you to be an actor. I wouldn't reveal that I actually need to have authorship in order to feel fulfilled." Yep, we've seen that for sure. Okay. All right. As alleged in the FAC, that is exactly what happened on the set of It Ends With Us. Almost immediately, Lively began inserting herself into the production process in intrusive ways, well beyond the scope of her contractual entitlements. Lively's intrusions started with the wardrobe, then extended to rewriting the script, which happened daily, and significantly disrupted the carefully planned production schedule and placed significant stress on the production crew and financial strain on Wayfarer. Although Lively's pattern of domineering interference is something I need to say more often, caused unending interruptions to the production process, leading to entirely unnecessary stress, chaos, and delays. Lively and Baldoni had a somewhat warm relationship during this early period of production. However, production was halted through the summer of 2023 due to the WGA and SAG-AFTRA strikes. Okay. The dynamic began to change during the strikes when Lively began inserting herself into the editing process. During the strike, Baldoni began editing the footage shot in the first phase of production. Lively's involvement took on a more insistent and manipulative tone. FAC 68 is, I didn't mean to read that. That's a citation. Lively began demanding access to the dailies, raw footage, as well as early cuts of scenes. For those in the film industry, such a request by an actor is highly inappropriate and unorthodox because it intrudes on the domain of the director. Baldoni and the film's editors feared that Lively's incremental demands would turn into a complete takeover. And it did. All right. After the SAG-AFTRA strike ended on November 9th, 2023, Baldoni, Wayfarer, and Sony were eager to resume production. That same day, however, Lively's lawyers blindsided them with a 17-point list of non-negotiable conditions that must be met before Lively would return to work. The list was drafted for the apparent purpose of insinuating or outright claiming that Baldoni, Heath, and others had engaged in sexually inappropriate conduct during filming. However, nothing could be further from the truth. When Wayfarer and Sony attempted to revise the document to make it factually accurate, Lively's counsel responded that the list was not open for negotiation. Wayfarer was forced to sign the document as is, despite the falsity of his insinuation, lest they lose millions of dollars, cost hundreds of people their jobs, after they had been out of work for months, and destroyed their relationship with Sony. God damn.
Yeah, this list was in the middle of production, right? It wasn't at the start. Isn't that correct?
Crazy. I think so.
Mm-hmm.
The list was sent the day before they were supposed to go back to work. So there was like a break in the middle of it. Yeah.
Right. So they were in the middle of production. Whereas normally, if you're going to have some sort of management policy, you would instantiate that at the beginning of a production,
Mhm.
right, and negotiate at that point before you basically sunk all these resources into the production.
Mhm. And there were no intimate scenes filmed prior to the strike, which is
Mhm.
why it was so confusing.
Right, right.
All right. Where did I leave off here? Did I read through this? The list was drafted yet? This part? List was drafted for the apparent
Mhm.
purpose of its. Okay.
Yeah, I think we got through that.
However, nothing could be further from the truth. When
Mhm.
Wayfarer
We
and
got
Sony
through the
attempted to-
open
okay.
for negotiation. Yeah.
Open for negotiation. Oh, there it is. Wayfarer was forced to sign the document as is, despite the falsity of its insinuations, lest they lose millions of dollars, cost hundreds of people their jobs after they had been out of work for months, and destroy their relationship with Sony. Notwithstanding the insinuations, however, the demands themselves were agreeable. Indeed, some were already in place. Regardless, as alleged in the FAC, Lively used the 17-point list to extort the Wayfarer parties and Sony into giving her editing rights, allowing her to create her own cut of the film, removing Baldoni from all marketing and promotional materials, sponsoring Lively for a PGA mark, which the Wayfarer parties characterized as extortion in real time, and excluding Baldoni from the premiere, among other ruthless demands. To the extent Wayfarer assented to these demands, they did so staring down the barrel of a gun. And I think that's metaphorical, but I'm not positive. In the FAC, the Wayfarer parties dismantle point by point the insinuations in the 17-point list. As outlined in the Wayfarer parties' pleading over a collective 391 pages, including Exhibit A, which was the timeline of evidence, Lively fabricated, materially mischaracterized, or grossly exaggerated all of the allegations she made in her CRD complaint and federal lawsuit. Okay. Lively falsely claimed there was no intimacy coordinator when Lively was aware that one was engaged 6 weeks before filming began. Yeah, this is the one she refused to meet with. Yep. Mm-hmm. Although she refused to meet with her in pre-production, forcing Baldoni to personally relay the coordinator's suggestions about the mechanics of intimate scenes. And imagine doing that and then being like, there was no intimacy coordinator, you know? So crazy, dude. All right. Lively falsely claimed that certain of the Wayfarer parties insisted on being around her when she was undressed or breastfeeding, when in fact, Lively openly breastfed on set, and no one ever entered her guarded trailer without advance permission. The FAC includes a text message from Lively to Baldoni from after the event she later recast as sexual harassment, inviting him to her trailer while pumping breast milk. Yeah, that's damning. Okay. Lively falsely claimed that she was forced to be nearly naked during the filming of a birthing scene when, in fact, she was wearing black briefs, a hospital gown, and a pregnancy suit, and only her legs showed. Oh my goodness. Yeah. Lively falsely claimed that Wayfarer hired a random friend of Baldoni's to play the gynecologist when in fact the actor is a Shakespearean-trained professional with an MFA in acting from UCLA. Lively falsely claimed she was shown porn by Jamey Heath, when in fact, in relation to the filming of a birthing scene, Lively was shown a single non-pornographic clip from a video of Heath's own son's home birth. My goodness. Lively falsely claimed that Baldoni harassed her during the filming of a purportedly soundless slow dance scene. An allegation definitively disproven by raw footage with sound that Lively apparently did not realize existed. Lively falsely claimed that Baldoni fat-shamed her, and this is something that I'm going to show in the series that I'm doing, guys, the series where I use your voices and your messages of support that you sent me for Justin and the Wayfarer parties. Is like when she claims that he fat shamed her. There's so many clips of him that I want to use that show like how like just like good of a person he is and how much he would never try to like insult anyone's looks or anything like that because he was bullied as a kid and he was made fun of for being overweight and all this stuff. That's just like I in this project that I'm doing, I just have so many things that I want to show that really break down all of these claims.
Mhm.
But anyways,
Yeah, I mean,
um,
if you have back problems and the movie script calls for you to carry, a sack of potatoes, and you're concerned about how much the sack of potatoes is going to weigh, you're not fat shaming the potatoes.
yeah,
No.
right. I mean, I totally am fat shaming the sack of potatoes. But that's just me.
Maybe if they're deep fried, but I don't know.
Yeah, maybe. An allegation definitively disproven by raw footage with sound that she didn't realize existed. Lively falsely claimed that Baldoni fat shamed her when in fact he privately inquired with her personal trainer, about her weight to prepare for a lifting scene due to his long history of back problems. Lively also falsely claimed there was no such scene, but the relevant portion of the script is excerpted in the FAC. Oh man. Lively falsely claimed that Baldoni admitted to committing sexual assault when, in fact, he disclosed that he had been the victim of sexual assault, which is, again, something very delicate and personal that if you disclose that to somebody should never be used against you. Like, that's so terrible. Like, I can't imagine how awful he must feel to have that thrown back in his face when he was trying to be vulnerable and trying to be, like a good person or a good director, a good friend, whatever it was in that context. Like, wow. Okay.
I could also add, not that I'm defending them at all, but there was also in her one complaint, she had said that there was a conversation that happened in front of Blake Lively's driver where he had said, "Oh, in past relationships, I didn't always ask for consent." And then the driver was like, "Oh, that's weird. Don't be alone in a room with him." I don't know if that happened. Yeah.
Yeah. Huh. Yeah, I couldn't really say either. We weren't there, but that's something to think about. Give me 1 second. I'll just load the chat for these people real quick. Okay, I put the slow mode on a little bit higher mods. Thank you. Okay. Anyways, the foregoing are representative examples. I think I read this already, and do not come close to capturing the full scope of Lively's fabrications. I can say the word. Suffice it to say, the FAC alleges in the strongest possible terms that the accusations made by Lively concerning sexual harassment and retaliation are false, and that Lively knows and always knew they were false. For the purposes of a Rule 12b-6 motion, it is enough that the Wayfarer parties allege in factually grounded and non-conclusory terms that Lively acted with malice and made her accusations without a reasonable basis in fact. The sharp factual disputes between the Wayfarer parties and Lively preclude a ruling on purely legal grounds. Okay. B, Section 47.1 does not apply to defamatory statements made by the Sloan parties or Reynolds on Lively's behalf. There we go. All right. Furthermore, Section 47.1, by its plain language, does not apply to the defamatory statements made on her behalf by her co-conspirators and agents, the Sloan parties and Reynolds. For the purposes of Section 47.1, communication is defined as factual information related to an incident of sexual assault, harassment, or discrimination experienced by the individual making the communication. Thus, the Sloan parties and Reynolds' statements fall into an entirely different category than Lively's own statements. Huh. I didn't think about that. Okay. Although not entitled to protection for the reasons discussed above, Lively's statements bear markers of baseline eligibility to the extent they relate to Lively's own experiences. In contrast, the statements of the Sloan parties and Reynolds, which also purport to relate to the experiences of Lively, were not made, as the statute requires, by the individual alleged to have experienced an incident of sexual assault, harassment, or discrimination. Okay. Section 47.1 does not extend to, and in fact is expressly drafted to exclude third-party communications. Given their lack of protection under Section 47.1, it is not necessary to separately analyze malice or reasonableness, although the Sloan parties and Reynolds statements fail on both counts. 6, the fair report privilege does not apply, which is something else I think we brought up earlier. The fair report privilege renders privileged a fair and true report in, or a communication to, a public journal of A, judicial proceeding, or E, of a verified charge or complaint made by any person to a public official, upon which complaint, a warrant has been issued. Okay. As Lively acknowledges, the fair report privilege is typically invoked by news media defendants in connection with publications concerning judicial proceedings. However, the privilege also protects those who communicate information to the media. But the fair report privilege, by definition, only applies to communications relating to an official proceeding, so Lively is forced to recharacterize the allegations against her beyond recognition. In Lively's telling, the defamation claim is based on her leaking the already filed CRD complaint to the New York Times, which subsequently published a fair and true report on its contents. This account diverges sharply from what is actually alleged in the FAC. As alleged, Lively, Reynolds, and the Sloan parties started working with the New York Times months before the CRD complaint was filed. Indeed, the New York Times apparently started working on its story, fed by Lively and her co-conspirators, as early as October 2024. Lively did not file her CRD complaint until December 20th, 2024. Okay. The crux of the FAC... Sorry, one second. The crux of the FAC is that Lively worked hand in glove with the New York Times throughout the fall of 2024. Feeding its reporters defamatory statements and coordinating closely with them to ensure the end result would amount to a kill shot to the Wayfarer party's reputations and careers. This had nothing whatsoever to do with any then ongoing judicial proceeding. When the New York Times finally dropped its bombshell multi-thousand-word feature nearly simultaneously with Lively's request for a right to sue notice, and by nearly simultaneously, they mean on the same day, which you wouldn't do that. And you wouldn't ask for a quote the night before that dropped or that was filed, right? Unless you knew it was coming. Okay. When the New York Times finally dropped its bombshell, it's legally pointless sham attachment plainly aimed at the public. It was after months of secret collaboration during which Lively and her co-conspirators made false and defamatory statements about the Wayfarer parties. At the time they were made, these statements bore no relation to any judicial proceedings, and they are therefore ineligible for the protections of a privilege predicated on the pendency of such proceedings. The fair report privilege does not protect Lively. Whew. All right. Let me read through some of these super chats in just a second.
Interesting.
Here. Yeah, right. Oh my gosh.
I mean, it reads as a good argument.
Yeah, it does. I mean, I think it does, but the filing that I read last night in comparison is just fucking terrible. So yeah. One second.
Mm-hmm.
I don't know if you heard or read any of the filing from yesterday, but it was
That was the response to one of the motion to dismiss, or what was that?
Yeah, it was Blake Lively's response to Jad Wallace's motion
Yes.
to dismiss. Jad Wallace being the crisis PR for Baldoni, who allegedly orchestrated this untraceable smear campaign. Also, we lost Be Better at some point, and
Yeah.
thank you, Be Better, for being here. He did tell me that he had to leave. I was reading, so I forgot. Sorry.
Yeah, that was an interesting one. I mean, it basically sounded like they were like, "Hey, look at this guy's job description."
Yeah,
I'm
right.
like, well, that you haven't proven he did anything nefarious. You're just sort of saying what his job is.
That's not even his job description. Like, you go to his LinkedIn page, you're not going to see that on it. That's like, okay, this is what other.
I mean, they're trying to
say,
characterize him, right? It was basically a document where they're characterizing him.
Yeah.
As opposed to saying he did X, Y, Z, they're saying this is what he does. See, and I thought it was a little wild.
So
this is an interesting argument. I think we'll need to see the lawyers weigh in. But it just sounds like basically they're saying there's all this activity before this thing was filed. So that basically nullifies the fair report privilege. It's a good argument, but I'm not a lawyer, so I don't know how good it is.
Yeah, well, I know this was this was part of what Omar really wanted to go over too. So we'll have to kind of fill him in on that a little bit. Hang on, let me see if I can get 1 second.
And I imagine the two lawyers will probably have something to say about that.
Oh yeah, of
Well,
course. They're usually on like at the end of my workday, so I'll listen to them while
right.
I'm writing my appeals or whatever. But I know they were on today and I had to miss it because I was super busy this afternoon, but hang on. I'm trying to get pictures of my dog from my mom, so I have to do that real quick. Give me 1 second. Every night I have to see pictures of my dog, or else I'm like, my dog. Because he stays at my parents' house right now with my sister and her dog, because he doesn't like to be without the other dog. So now it's like, well, what am I? I thought I was your bitch. But no, apparently my sister's dog is. So, yeah. Anyways, I'm sure everyone was wondering about that. So,
Canine popularity, it's fleeting.
moving on. All right. Nor does Lively address the defamatory statements made to those other than the NYT. Those include those made by her agents and co-conspirators, Reynolds and the Sloan parties, in the summer of 2024. As alleged, in or around August 2024, the Sloan parties made defamatory statements to the Daily Mail and other outlets to the effect that Baldoni is a sexual predator who sexually assaulted Lively. Reynolds, on at least 2 occasions, and around July 2024, and we read more about this in the last couple days. I can't remember which filing it was. It wasn't because last night was Blake responding to Wallace, but 2 days ago it was God, what was it? Oh, it was Justin Wayfarer responding to Reynolds, where they talked about this a lot more.
Right.
Right. Okay. Reynolds, on at least 2 occasions, made statements to WME execs to the effect that Baldoni is a sexual predator and that WME was in business with a sexual predator. These statements are even more attenuated from any judicial proceeding than those made to the New York Times, and they were made at Lively's direction as part of a conspiracy to destroy the reputations and careers of the Wayfarer parties. Okay. 7. The FAC alleges that Lively acted with actual malice. As a matter of constitutional law, if the person defamed is a public figure, he must prove by clear and convincing evidence that the statement at issue was made with actual malice. Okay. For example, with knowledge that it was false or with reckless disregard of whether it was false or not. The Supreme Court has explained that while the concept of reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious doubts as to the truth of his publication. Okay. There is compelling evidence that Lively fabricated her accusations. I agree with that. I mean, God, if this wasn't enough, the first 30 pages we read of this, then I feel like... And I remember, Bruce, you were with me when I went over that first amended complaint also.
Right.
So we know there's compelling evidence. I don't remember if you were with me when I read Lively's amended complaint. I think you were, because it was like that late night. It was like midnight when it came out. And we were going over the whole thing. And it took me 5.5 hours. I think you were with me until almost the end of that.
Yeah, that was wild.
That was wild. I was like, oh my God, I can't believe this is happening right now. I remember I had been texting Dave Neal all day. I was like, Dave, it's not out yet. Because this is before Dave knew how to get the documents himself. So I was like, Dave, I'm checking. Dave, it's not out yet. It's not out yet. It's not out yet. Like every 15 minutes.
Yeah.
He was probably like, God, you're crying worse than August. Like, it's ridiculous.
Probably. I mean, what's the alternative here? I mean, she made all these accusations, and it's like either that you're sort of stretching the truth here, right? Or like, what's the alternative? Some sort of delusion? I mean, I don't know how they're going to get out of this.
I don't know. I mean, my kind of perspective on these things is delusions are very strong and very specific. I don't see any delusions here. I see a lot of working around this and trying to make it fit, and that's not what you do with a delusion. If you are really delusional, you just believe it to your core. Anything anyone else says doesn't matter. You know the truth, and that's it.
It's more like manipulative rationalization or something,
right.
Maybe is a better term.
Yeah. All right, let's see. Where are we at here? Okay. Lively's bald assertion that she believed her statements about the Wayfarer parties, which is at odds with the allegations in the FAC, carries little weight and is easily rebutted. Lively's mere professions of good faith are not persuasive, especially where other mitigating factors are present. Defendants cannot automatically ensure a favorable verdict by testifying that she published with the belief that the statements were true. The finder of fact must determine whether the publication was indeed made in good faith.
The old trust me, bro defense.
Oh, man. How often does that work, you think?
I don't know. Not often.
I don't know. I haven't tried it much yet, but I'll let you know what my percentage is when I'm done. All right. Factors such as failure to investigate, anger and hostility, and reliance on unreliable or biased sources will create the inference that Lively had serious doubts regarding the truth of her statements. Yeah. Okay. Moreover, malice will be inferred if the defendant fabricates her story, it is the product of her imagination, or is based wholly on unverified information. Lively's motive for making the statements and whether she did so to harm the Wayfarer parties are also relevant. As to the allegations of sexual harassment, Lively clearly knew they were false at the time she made them because she was describing her own purported experiences. As outlined above and exhaustively detailed in the FAC, Lively was not sexually harassed on the set of the film, and she grossly mischaracterized or outright fabricated the events in question, even in sworn legal documents. Lively and her co-conspirators engaged in a coordinated campaign to exaggerate benign interactions in service of a false narrative that Lively had been sexually harassed. They did so to instill terror in the Wayfarer parties and leverage it to accumulate power. This accumulation of power depended upon the ability to conjure and exploit ruinous allegations. The allegations were never true, and Lively knew it full well. Lively's insistence she believed her allegations is, in addition to not being properly before the court on this motion, belied by the allegations in the FAC, the surrounding facts and circumstances, and the evidence already presented by the Wayfarer parties. At a minimum, Lively makes factual contentions properly reserved for the jury. Lively also knew that the smear campaign narrative was false or acted with reckless disregard for its truth. With her co-conspirators/agents, Lively got a hold of communications between the Wayfarer parties from Stephanie Jones that disproved the claim. So we're just saying out right now, she got it from Stephanie Jones that disproved the claim that the Wayfarer parties had orchestrated a smear campaign. Given that she had these materials, Lively either knew that the narrative she and her agents later publicized was false or, at best, disregarded such evidence. It also would have been clear to Lively, a long-time Hollywood fixture and the wife of a marketing company owner, that her negative publicity was precipitated by a series of off-putting public appearances and her puzzling decision. Oh my God, we're saying this again. This is like they said this in the filing the other day.
Yeah.
Her puzzling decision to hawk liquor and hair products while promoting a film about domestic violence. Oh my gosh, that's the truth.
Oh, now I need a drink.
And some shampoo, maybe.
Mm-hmm. It is interesting about the point about the time. You know, the timeline is so important in this case, and it's a very interesting point about the timeline of those text messages. In terms of what did certain people know when, in terms of that going to the knowledge that would be required to show in a defamation case.
Yeah, right. Oh, Julie Baby 19 says, I'm so excited for Justin Baldoni. I need to read through some of these real quick. We got through that. We got through that. Hang on. She also knows Rule 26. Thank you for the $2. Cat Lady Ballerina. Zach, thank you for the $2. Roast battle activated.
Oh, no. Rule 26 is out. Rule 25 is in.
Yeah, right. Memoy now. Thank you for the $5. I appreciate the super sticker. Zach, again, thank you for the $2. Yeah, Omar needs trolling lessons from me. I'm sorry. I think I was supposed to read this earlier, but I didn't. I'm sorry.
Oh, boy.
Let's see. Zach, thank you for the $2. Lauren's part of the LGBTQ coalition. Something like that. Yeah. I'm really just, I'm just a part of my life. I don't give a shit about anyone else. Just kidding.
We exist.
I totally do. I totally do. I'm just kidding. Sugar Queen, thank you for the 99. I don't know what currency that is, but either way, you're awesome. So I have not seen that symbol before. Fred74, thank you for the $5. Hey, Be Better and Lauren, love this collab. What about the thousands of pages New York Times says they looked at? Do you know yet what that is and who from? Apparently, it was from Stephanie Jones. And apparently, it was obtained illegally. But apparently, we don't have a judgment yet. So, all right. And Chai H, thank you for the $10 super sticker. I appreciate you.
I mean, we noted that as being very sus a long time ago, right?
Yeah. Yeah. I mean, I went through this whole thing where I was like trying to argue and like, apparently these states you can get a subpoena without a blah, blah, blah with it. But at the end of the day, it seems like Stephanie Jones did not need a subpoena to get information off the company-owned device, even though they were personal text messages. It was a company-owned phone. And you know, when you sign that contract and you use the company-owned device, unfortunately, the company does, in fact, own all of it. They can see anything legally. So they got that all from Celebrite, and then they illegally, sent that to Blake and apparently Vision PR and Leslie Sloan, who bragged to, I think it was Melissa and Nathan, the same day that she was going to get sued over her text messages, which was incredibly stupid. Incredibly stupid. Like, why wouldn't you keep your damn mouth shut until the lawsuit was filed? Like, good job, because you did the worst thing you possibly could do for yourself, and you're in the wrong here, so that doesn't bother me at all. But just saying, why the fuck would you brag about that? Be like, I know what you said in your text messages before a subpoena was ever served. And then be like, confidently with your chest, you're going down. You know what I mean? Like, no, you're an idiot for saying that before the lawsuit was even filed. So, yeah. All right. Moving on. And we're getting towards the end here, guys. We have 13 pages left. So, okay. The fantastical notion that the backlash was caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. Taken collectively, the allegations in the FAC are more than sufficient to create an inference that Lively acted with actual malice. That is enough at this juncture, even as the Wayfarer party look forward to gathering more evidence and proving their case at trial. Oh, man. Finally, while the FAC satisfies the Wayfarer party's pleading burden under actual malice standard, it is important to note that 6 of the 7 Wayfarer parties are not public figures. So Heath, Sarowitz, Abel, Nathan, It Ends With Us, and Wayfarer. The mere involvement of a person in a matter which the media deem to be of interest to the public does not, in and of itself, require that such a person become a public figure for the purpose of a subsequent libel action. All right. Sorry, guys. Because the FAC satisfies the burden of actual malice as to all the Wayfarer parties, it is unnecessary to analyze the lesser standards. B. The Wayfarer parties have adequately pleaded a claim for civil extortion. As an initial matter, Lively claims that the FAC does not identify a single threat made by Lively, but that is facially false. Do they mean facially or factually? I mean, facially, I guess, works too, but I've never heard anyone say it like that in a legal document.
On the face of it.
I get it, but at the same time, it's like, I mean, Bruce, it's for the court, it's not for us. I know, but still, at the same time, it's like facially false. Never mind. You know what? I'm not going to be a perv. I'm going to keep moving. The FAC recounts in detail an instance in which Lively and Reynolds demanded that the Wayfarer parties issue a humiliating and false statement taking blame for Lively's press woes, or else the gloves would come off, as well as making an express threat that Lively and Reynolds themselves would attack Wayfarer in the press if Wayfarer refused. Furthermore, the FAC alleges that Lively obtained first a producer credit and then the coveted PGA mark by threatening and coercing the Wayfarer parties into granting her the credit and writing a letter of support for that mark, an act that Jamey Heath expressly recognized even at the time as extortion. These allegations
and we've seen
alone,
that, right?
Yeah. And that, remember when we spent, it was like 2 days and 6 hours between the 2 days. No, it's like 7 hours between the 2 days. Yeah, that was one of those things. These allegations alone are sufficient to defeat Lively's motion to dismiss the Wayfarer party's claim for civil extortion. Like her husband, Lively claims that California courts have not recognized the tort of civil extortion, but one of the very cases she cites belies that argument. The California Court of Appeals stated, "We assume there is a cause of action for damages based on economic duress, which some litigants have alternately denominated civil extortion." Okay. And that was in one of the cases they cited, not this case. All right. Alternatively, Lively claims the tort is limited only to extorting money through threats of prosecution, but points to no authority that California courts so limit the claim. Under California law, the exact contours of this common law tort are not so strictly defined. Contrary to Lively's assertion, courts recognize that California's civil extortion claim is based on the law of criminal extortion. Courts applying California law hold a civil extortion claim will not lie only where obtaining money was the aim, to the exclusion of other consideration being taking over the film, I guess.
Well, things like the producer credit and the PGA annotation, right?
Yeah.
And it's very interesting because in a lot of these cases, what you'll see in these arguments is one side is trying to have a very narrow interpretation of something, and another side will argue a broader interpretation. So it's interesting to see that theme come up.
Victoria, thank you for the $10. I'm way behind in the live. Also in Jax. No way. And wanted to go to law school years ago when there were no good options. Went the mental health route instead. Hope you go for it. Thank you for all the late nights. Well, Victoria, thank you very much. Good to see another local here. And also, same. I went the mental health route instead. I grew up in a family of psychiatric professionals, so that's just how I ended up when things didn't work out the way I wanted them to. But that's interesting that you also had the same experience. Maybe we should, talk sometime about that. That'd be cool. Anyways, I'm always looking for new friends in the area because all mine moved away. And so now I only have Bruce. I'm just kidding.
We do what we can.
It's fine.
We muddle through.
Hey, for the record, I've never visited Wisconsin. So are you going to change your name to Bruce from Wisconsin, or are you going to stay Bruce from Oregon?
Well, here's the thing. One of the places I'm looking at relocating to is a small town or a village called Oregon, Wisconsin. So if I manage to pull that off, I don't have to change anything. Yeah, there's a little town called Oregon.
Wait, that's actually crazy. I had no idea there was an Oregon, Wisconsin. I feel like they made that just for you.
So, yeah, I know. It's funny.
Oh, Omar's back. What's up, man?
What's up, folks?
Hey, how's it going?
Oh, what a mess.
Wait, how do I email one of these people? Lottie, which people? And also, let's see. Lauren is getting delirious from lack of sleep. Hey, it's not even midnight yet, bro. But yes, you're right. We've been over the 47.1 argument. I don't know if you want to skim back through that before we get to the rest of this. We're in the last 10 pages right now.
Oh, you don't got to. It's cool. Unless there's something pressing question. I'm going to end up reading this later anyway.
Yeah, no problem. Okay. So we're going to move on to.
Yeah, actually, the two sections you missed are probably the most interesting.
They might be.
For you.
That's true.
Yeah. Well.
Oh, man.
At least for your perspective.
Now, somehow I'll muddle through.
Yeah.
Cheesehead Bruce. Somebody says
That's
Cheesehead
right.
Bruce.
Go Pack Go.
Bruce from Oregon, Wisconsin. All right. Let's see. But even where were that not the case, California law prescribes extortion, notwithstanding ultimately obtain no money or property but by means of extortionate threats. Here, the Wayfarer parties have alleged facts sufficient to state a claim for civil extortion based at least on the demand by Reynolds and Lively that the Wayfarer parties issued a self-destructive statement taking blame for Lively's press woes, or else the gloves would come off and they would attack Wayfarer in the press. The FAC thus alleges that Lively, as well as her husband, I like when they reduce him to her husband, expressly demanded consideration and, if the Wayfarer parties refused, threatened their business or property interests. To the extent that the Wayfarer parties' factual allegations do not suffice, the court should grant leave to amend. C. The FAC pleads a claim for false light invasion of privacy. Okay. Under California law, the false light claim is not duplicative of the defamation claim. The cases that Lively cites for this proposition are inapposite. And this is where I'm going to skim through a lot, guys, because that's something that Omar can tell you a lot more about later on when he reads the whole filing. All right, here by contrast, the Wayfarer parties allege not only that Lively conspired to defame them by means of false and harmful statements, but also that Lively and others conspired to place the Wayfarer parties in a false light by means of false statements and distorting factual statements beyond recognition into falsehoods. Were you trying to say something, Omar?
Oh, me? Oh, no,
Yeah.
I was reading a comment. Somebody named Lottie says that Omar has the theory mostly right, but I'm missing something. I'm wondering what I'm missing.
Oh, man, I don't know. She'll have to watch
What
your
is the
stream.
missing piece? She should show me the way.
Yeah. Send you an
Wait.
email.
The court of random opinion P99 is 99 through PayPal. That's amazing for you. I
Oh my
don't
gosh.
know
Is
what does that mean? I don't know what that means. But even if it was 99 cents, dude, I'm very happy with that because somebody liked me enough to do that. So thank you very much. However much it was, whether it was 99 cents or $99 million, thank you very much. I appreciate it. And I appreciate everyone being here.
Lauren, if it's
Even if you
$99
have
million,
nothing to do.
we need to talk.
No, we won't talk because I will buy new people to talk to. I'm just kidding.
Lauren gets $100 million. She won't tell anybody, but there will be signs.
If I get $100 million, I'm buying a house next to yours in Oregon, Wisconsin for vacation.
Oh, nice. We could buy the whole block. Yeah. Have a compound.
Oh my
YouTube
gosh.
compound.
Yeah. Oh my gosh. So I have to turn my phone down because I keep getting
This is
David
interesting.
Gingras tweet notifications. I'm like,
gosh.
case crossover I didn't ask for. Okay,
Omar, do you know
anyway.
anything about this section? It appears they're arguing that the false light claims and the defamation claims are not mutually exclusive.
Yeah, in
They can be done
California,
orthogonally. Do you agree?
in California, there's a very slight difference that New York doesn't recognize.
Mhm.
But in California, if you attempt to purposefully portray somebody in a false light, then that is a separate cause of action.
Mm-hmm.
It's not
Okay.
exactly the same as defamation because defamation is literally, publishing a statement and all of that.
Mhm.
But portraying somebody in a false light, it kind of goes hand in hand. There's subtle differences. And then what they had said in the opposition was California recognizes it as a separate cause of action. Just because they're based on the same set of facts is not a reason for dismissal. What it means is if one falls, the other is likely to fall. But they are separate and distinct causes of action if we're using California law, and it appears like they're gonna. So that's what that's about.
Okay.
I totally knew that, mister. Sorry. I'm trying to send my brother, it's his birthday in 4 minutes. I'm trying to send my brother a link to this stream so he can watch them.
Wow, happy birthday.
Yeah, dude, he's an old man. It's fine.
Well-
He's 12 and a half years older than me, so he's about to be 45. But yeah. He's just sent me a text. I wrote a card for him and I was like, Mom, give him this card. I can't come to the whatever they went to earlier because I was working. So yeah. He sent me a thank you text and I was like, by the way, I'm on the YouTubes now. You should check it out. All right.
Hey, so I heard that Dingus debated Rachel the judge or something.
Rachel Juarez.
I'm sure that
Rachel
went well for
Juarez.
him. Yeah, right.
Well,
With
I've heard
I've
heard
a debate.
that
coming out
Dingus
tomorrow.
talks like 80% of the time
That's what.
and still got his ass kicked.
Well, we'll see tomorrow.
I mean,
Buckle up.
I'm paraphrasing, but anyway.
Well, oh man, Sherbert says, love hearing Lauren's laugh. Well, then you should listen to me read one of David Gingras' filings.
I mean, sometimes people don't understand that they have a shovel and they're digging themselves a hole and they don't know to stop digging a hole. You know what I mean?
Wow.
And I think that's what we might see tomorrow, but let's find out.
Oh my God.
It'll be entertaining to watch. A hell of a way to start the day.
Well, I look forward to it.
Do you know what time it drops, or?
Yeah, at 9 a.m. Eastern.
9 Eastern? Oh, geez, I
Yeah.
gotta get up early then. Oh my gosh. I gotta get to Wisconsin here.
Is that a joke? Because Easter's on 420, and that's a long time from now.
Yes.
Eastern time zone, not
Okay.
Easter, the holiday.
Oh, dropped on Eastern. Let's go with that.
Sorry, I thought you meant Easter the holiday. I was like, what are you guys talking about? Like, what are these idiots talking about right now? All right, anyways.
Lauren, I know Easter is on 420, and it's not even that time yet, so it's not
Well,
time to get baked yet. I mean,
I didn't know until I went a couple days
Oh,
ago to
boy.
get I went to get my hair cut at a Great Clips, and the lady was talking to me because there was no one else in there except for me and her because it's a Great Clips. And she was like, well, Easter is on 420 this year. And I was like, oh, I got to pick one.
Oh,
shit.
boy.
Anyway,
This is the gummy hour for Lauren. You never know what you're going to get past midnight with her.
it is, but I haven't taken a gummy because I'm reading this thing. So let's get over it so I can take a gummy, go to bed, and then I'll do a short recap of this filing in the morning, like I said, guys. So yeah. Anyways, moving on. California law has long recognized that the torts of false light and defamation are distinct claims with related but separate elements. I am going to skim over this shit here. Let's see. To the extent that there are any defects in the Wayfarer party's false light claims, the defects can be readily cured by amendment. Courts applying California law readily grant leave to amend claims for false light. Okay. Of course, because the actions of Lively and her co-conspirators were carefully concealed, less particularity is required when it appears to defendant that defendant, not I don't know why I said it like that. That defendant has superior knowledge of the facts, so long as the pleading gives notice of the issue sufficient to enable preparation of a defense. Okay. The court should grant leave to amend to the extent it is not inclined to deny the motion in its entirety. Omar, how common is that? Is that usually something that works out, like, with the leave to amend? Yes, Lauren. It will totally work out in the favor of the people that you like.
Oh, boy.
Justin's
Oh,
going to
Omar.
win everything, Lauren.
Oh.
I know you love him.
We got to work on your Omar impression, Lauren.
That's the best I got, bro.
Maybe Jingris can give you some pointers on the Omar impression.
I didn't think that Jingris.
He likes doing an impression.
I really didn't think that Jingris' impression of Omar was that bad. Oh man! All right.
I don't know.
Oh my goodness! I need to take my allergy medicine. I got bit by a spider earlier. It's pretty bad.
It's that time of year. I know everybody's
Yeah.
feeling symptoms if they're susceptible.
Anyways, I guess we lost. Wait, that was an Omar impression. Okay, yeah, you need to practice. Hey,
Yeah. We have a lot of
This
work
was-
to do.
this was Omar after getting kicked in the nuts. Oh, you're back. You're back.
Even though I thought I had kicked myself out.
Oh boy.
No, man, you were still here. I asked a question and I answered for you since you weren't present. I asked, how often is it that they would grant a leave to amend rather than just dismiss entirely? Like, is that? Are you gone
Well,
again?
it's if they don't dismiss it.
Please don't leave me again. I don't want to do another impression.
Because I imagine that a judge looks at it, and if it's obvious they need to dismiss it, they'll just dismiss it. But then if they don't, there's this option to allow them some leave to amend.
Yeah.
Once they learn more, or maybe do discovery. I'm not sure.
Yeah. Yes, Bruce,
You know?
totally. It's me,
Oh,
Omar Serrano, Esquire.
Esquire.
Wait, hang
Oh
on.
boy.
No, I can do this. Oh, he left me.
Oh,
No, he got disconnected.
He was
this time.
offended by your impersonation.
No,
of
no,
me.
I can fix it. I can fix it. My balls
Yeah.
dropped.
Oh,
Bruce,
right now?
I agree. It's me,
Wow.
Omar Serrano, the tilted lawyer with a sparkly. Wait, can I make my lights purple? Because that would help. Hang on.
You got to slow it down. He's kind of like,
Wait,
this is the tilted lawyer, and it's family law after
here we
dark.
go.
And
Hang
it's
on. I
family time.
got the blue lights on and everything. Hang on. There we
This
go.
is not legal advice, so light a cigar and pour
It's
yourself
me,
some
Omar.
Woodford Reserve.
Wait, you see he's backstage now, but I'm not gonna let him
No.
until I'm done.
Oh
It's me.
no!
Hang on. This is me, the Tilted Lawyer. I practice law in California, and I drink whiskey sometimes, but not all the time, because my little girls like to shout into my microphone when I join my friend Lauren's stream. Grab a
lower the
glass,
voice and
sit
slow it
back.
down. That's the Omar.
I'm a lesbian, not a man. Temper your expectations, sir. All right.
Oh, boy.
It's me. Oh,
You got the lights. You got the lights a little close. You need to get one of those steam machines or whatever he's got. The little diffusers. You gotta get those. Wait,
Look.
does he put essential oils in there? Oh, there he is. Omar, do you put essential oils in those diffusers? Or
I totally do, man. It smells delicious. I make like little flavors. Like the other day, I had like a cherry pie. Like I put cherry oil with like some shortbread, and it smelled like a cherry pie. It was delicious.
Oh my gosh!
It always smells delicious wherever I'm at, or whenever I'm podcasting. Anyway, that impression that you just did was better than gingerbread.
That's a mark of honor. Thank you very much. Can I get my PGA mark for the stream now?
Fuck yeah, you can.
All right. Let me turn my
Man.
lights back to white, please. Okay, we're good. We're good. I was feeling a little blue, but now I'm good. All right. Anyways, the FAC adequately pleads tortious interference claims against Lively. The FAC pleads a claim against Lively for tortious interference with Wayfarer's and Baldoni's relationships with WME, a preeminent talent agency in Hollywood. WME is the same agency that represents Lively and Reynolds. Accordingly, Lively knows and understands as well as anyone that the Wayfarer and Baldoni relationships with WME were contractual in nature, and that their terms consisted of WME procuring film and entertainment projects for Baldoni and Wayfarer in return for percentage commissions of their clients' earnings. For the same reasons set forth in opposition to Reynolds' motion to dismiss, this cause of action... I get it. Okay. Lively's motion should be denied, or leave to amend should be granted to cure any pleading deficiencies. The FAC alleges that Lively and Reynolds, who are two of the most powerful stars in the world, demanded through their talent agency, which also represented Wayfarer and Baldoni, that the Wayfarer parties publicly apologize for so-called mistakes during production, or else the gloves would come off. When those coercive demands were refused, the FAC alleges that the gloves came off. And this looks exactly like the response from the other day to Reynolds, but I mean, that makes sense. Finally, the FAC alleges Lively's threats and demands included WME to cease performing under its contract with the Wayfarer parties. Because talent agents are typically paid a percentage of the client's earnings, it can be inferred from these allegations that WME would fear its own economic harm
This
from
is the
attacks.
business tours, isn't it?
Huh?
This part is super boring. This is the business tour.
You missed the fun part. Hang on.
I know.
Harm from attacks on Baldoni and Wayfarer, and would be coerced to drop Baldoni and Wayfarer to maintain more profitable relationships with much bigger stars, such as Lively and Reynolds, who would generate larger commissions. This is exactly what they wrote in the response to Reynolds. So let me see if anything's different here while I skim over this real quick.
I mean, they're connecting the dots, right?
Yeah, of course.
Yeah.
Mm-hmm. Yep. So this is talking about how they said WME was working with a sexual predator, and they demanded to drop Baldoni. Were apparently uttered by Reynolds, not directly by Lively. However, given the context, even these statements could only be understood by the alleged listener, WME, as having come with Lively's authorization. Omar, what do you think of that?
Well, they're just tying it all together. They're just saying if the defamation claims are true.
Yeah.
And then if we can prove civil conspiracy, then that coincides with these business torts, where he's directly using malicious defamatory statements in a conspiracy to take over a film that is harming his future economic interest with future employers, and specifically preventing him from performing under the current contracts of the movie. That's what the business torts are. It all ties together. Defamatory statements were the ammunition. The conspiracy was the plan. And the resulting of those two led to these business torts, which also have their own separate damages. And so if you prove all the other stuff, then all this stuff, if you pled correctly all the other stuff, then the pleadings for these causes of action, all you guys say is how it somehow affected his finances, saying that we pled already that he to his future employers and all these things. That's how it fits.
I mean, the fact they're all under WME is the connective tissue between these things.
Mm-hmm.
Yeah, and the group pleading aspect of it, the Wayfarer parties is how they're labeled. They're all connected in the movie. With Baldoni specifically, I think that wasn't he the one that was he was the only one that had the specific cause of action related to, I forget what it was. But with Baldoni specifically, when they were going around calling him sexual predator to all of these people that he's supposed to maintain relationships with for future employment. That's the nature of the business towards. And so, but they also make it some admissions like, look, I realize that we weren't as artful as we could have been when we made these initial pleadings, but we can fix it. And we got more information. And so the end result is they're going to be granted leave to amend, and they will amend it. But it's not going to be a full out denial of Lively's 12b-6.
Mm-hmm.
I think the judge is going to be like, you said you could fix it, so fix it. Fix what you could fix. So there's going to be a second amended as to all of these things.
Yeah.
And all it's going to be is just filling in more facts. That's all. But it's pretty normal that you don't have all the facts at the beginning of a lawsuit, and you learn more through discovery. That's all it's saying. It's pretty common fare. There's nothing really to write home about here.
Yeah.
Yeah. All right. Well, let me skim through some of the rest of this. There's only 8 pages left, and we'll get through the meat of it. And then I'll go to bed. Okay, so let's see. We got through that. They said Baldoni was a sexual predator. He was working with a sexual predator, demanded they drop him. Let's see. The FIC states a claim for intentional interference with contractual relations, which again, this is pretty much the same that they argued in the Reynolds response. Lively argues there's no allegation that WME's contract with the Wayfarer parties was disrupted. However, the FAC alleges Lively induced WME to cease performing under its contract with the Wayfarer parties. That is disruption. Further, the clear implication in the factual context of a talent agency being pressured by 2 megastar clients to drop a smaller one is that Lively's threats and demands, including a demand conveyed through Reynolds that WME drop Baldoni, caused WME to do exactly that. Lively calls these allegations threadbare, citing soil retention products versus Brentwood. Okay, but the allegations concerning Lively's own relationship with WME, Reynolds, and Lively's communications with WME, and WME's communications with the Wayfarer parties are far more fulsome than the allegations in that case. All right. And even then, dismissal in that case was granted only with leave to amend.
Interesting.
Okay.
I want to know more about the soil retention.
Of course you do.
I got some soil retention for you.
Oh, boy.
I'm a lesbian, not a man.
We've established that, Omar. Thank you. You're so gay. All right.
Both of you?
Finally,
I'm in a lesbian sandwich here. Up and down. Oh, boy.
don't pretend this isn't exactly where you wanted to be at the end of the night. Come on, man.
That's fair.
All right. Okay. Anyways, alternatively, the FAC states a claim for intentional interference with prospective economic advantage. We're going to skim over this. As set forth above, the Wayfarer parties have pled intentional interference with contractual relations, even if their contracts with WME were terminable at will, because Lively is at least vicariously liable for defamation, which is an independent wrongful act. However, in the alternative, the Wayfarer party's tortious interference cause of action may be deemed intentional interference with prospective economic advantage because their relationship with WME probably would have resulted in an economic benefit to the Wayfarer parties as well as a run-on sentence that takes Lauren's breath away. All right. To show an economic relationship, the cases generally agree that it must be reasonably probable the prospective economic advantage would have been realized but for defendant's interference. All right. Lively is liable for her direct actions as well as by conspiracy. Okay. The Wayfarer parties have not brought a standalone claim for civil conspiracy, as conspiracy is instead a legal theory by which parties may be jointly liable for an underlying wrong. All right. The burden of proving, let alone pleading, tort liability on a theory of conspiracy is not high. What does that mean? resident lawyer,
Oh,
lesbian.
what was the
Burden of proof.
question? I was reading the comments.
Yes, Mr. Lesbian. What does that mean? The burden of proving, let alone pleading tort liability on a theory of conspiracy is not high. And then they said,
Oh, they're just saying if you could prove the conspiracy, which is a much higher standard, clear and convincing evidence,
Mhm.
then showing that somebody was involved in the conspiracy is a much lower burden.
Yeah.
Preponderance of the evidence. It's much easier to do that. So if they prove their conspiracy case, and that's tough to do, but showing that you had involvement in the conspiracy, well, that's pretty. It's not as hard.
all right, let's see. Wayfarer parties pleaded ample allegations in connection with each cause. Okay, to support existence of conspiracy. Let's see. It's regarding Reynolds with a joint threat to attack Wayfarer in the press. Okay. The FAC states a claim for breach of implied covenant of good faith and fair dealing. Okay. Lively also argues that the FAC fails to state a claim for breach of the implied covenant of good faith and fair dealing for failure to identify a specific contractual provision that was frustrated. The Wayfarer parties can and will amend to add additional specifics if needed. For example, Lively's contract requires that her right to consult and approve on certain aspects of the film's production and marketing be exercised in a reasonable manner, and not so as to frustrate Wayfarer's full and timely development, production, and/or exploitation of the film, and/or to force Wayfarer to bear any additional costs with respect to such consultation or approval rights.
That's interesting.
Yeah, I've never heard that. Actually, I haven't heard much about the contract at all, or...
Bro, I zoned out. But I think that what they're saying is, it sounds like what they're talking about is, are they talking about breach of contract stuff now?
Yes.
Yes.
Are they trying to say that Lively, is this the part where she made it impossible to perform in the contract and whatever concessions that were made
Yes.
for the result of her undue influence, and they made them under duress, all of that?
Yeah.
Apparently.
All right.
They're just saying we could produce the contracts and argue it.
Oh, yeah. Well, that's going to be actually an interesting part because a lot of those contracts weren't even signed.
That's why I said this is interesting.
Yeah. And then you know, there's a lot of people under misconception that you have to have a signed contract in order for it to be enforceable. It's just not the case.
Mm-hmm.
This sentence is interesting. Lively even argues, apparently with a straight face, that she did not fail to cooperate with the Wayfarer parties. That's a little dig. That's a good dig.
No problem. It's fine. It's all fine. Okay. Let's see. Where were we at here? Contract requires the right to consult, blah, blah, blah.
Yeah.
Okay. The contract further specifies Lively would not have the right to terminate her performance under the contract except in extremely narrow and inapplicable circumstances. Yet, as alleged in the FAC, Lively threatened over and over to terminate her performance of both acting and promotional services. Yikes. Lively also agreed that she would not do any act that would interfere with the complete enjoyment of the rights and privileges granted to Wayfarer. What does that mean exactly? Because I don't understand. What does that mean? Won't interfere with the what? Interfere with enjoyment and rights and privileges?
So whatever the rights and privileges laid out by the contract, when you hire someone, they're saying like you can't interfere with these things.
Yeah.
That are laid out in the contract. I mean, they're abstracting it a little bit here.
Sure.
But they're basically just saying she made a claim. We can show the contracts, even if we need to amend it, that would refute these claims.
Okay.
She's also claiming breach of contract as well, right?
What's that?
She's also claiming breach of contract as well, right?
No, that was Jones, I think.
I don't know. She said it says Lively's claim that she did not frustrate any specific contractual provision. So she's claiming she didn't frustrate contractual provisions.
Okay. So in other words, frustrating the purpose of the contract means that somebody's preventing the other side from abiding by the contract. So for example, the nudity rider provision, she argues that there was no intimacy coordinators. Like, well, that's because you effing freaking told her to F off when she was provided. That was your bad. You waived it.
Right.
And now you claim that we're somehow in the wrong. No, we provided it. And you didn't let her in the room because you said you had this. Mm-hmm. And then all the other stuff that they talked about.
Yeah.
just frustration of the purpose of the contract, doing something that makes it impossible to perform. That's what Wayfarer argues. Lively saying, I didn't do that. And that argument is going to be interesting because Bruce, a long time ago, you and I, like months ago, were talking about it's really stupid of them to keep on like giving in to her requests because she's going to argue that all these times that she presented them with an alternative, they went for it. That was them basically modifying or agreeing to modify terms of the contract. And I said at some point it's going to rear its ugly head, and this is kind of where it is.
An implicit acquiescence. Yeah.
Yes. Yes.
And you can get, in terms of management, you can get into big trouble. So, for example, in the tech industry I work in, the place I worked, there were two types of employees: contract employees and full-time employees. And managers actually had to be sure to follow very specific, rules about rights and privileges. Like, you couldn't just treat the contract employees the same way you treated the full-time employees, because then the contract employees could turn around and sue you. Yeah. So it's very analogous here.
Yeah.
So there's this stuff. We're pretty much at the bottom now. There's this stuff down here I want to ask about. Let's see. Well, we got through this. Lively's claim that she did not frustrate any contractual provision of frivolous. Her motion to dismiss should be denied. Okay, she's not entitled to damages or fees for the same reason she cannot prevail on this motion, namely that her motion raises disputed issues of fact that cannot be resolved at the pleading stage. As set forth in greater detail, each of Section 47.1's three prerequisites implicate matters of disputed fact and cannot be determined as a matter of law on motion to dismiss, where the court must construe all factual allegations in the complaint as true. Furthermore, Section 47.1 cannot be used as a basis for an award of damages or fees for the same reason that New York's anti-SLAPP statute cannot provide a basis for award of fees to the other consolidated defendants on their motions to dismiss. Applications of the law at this stage would conflict with Rule 11 of the FRCP by imposing a draconian and mandatory sanction where a defamation plaintiff brings a non-frivolous claim that nonetheless does not survive a Rule 12b6 motion to dismiss. All right.
Wait a minute. Did they just argue that 47.1 sanctions or attorney fees are not applicable in a federal case?
I don't know. I think they're saying...
Did I hear that correctly?
I think they're saying it cannot be used as a basis at this stage. So hang on, let me read that one sentence again. Furthermore, Section 47.1 cannot be used as a basis for an award of damages or fees for the same reasons New York anti-SLAPP statute cannot provide a basis.
They're saying that it doesn't apply in a federal case
on their motions to dismiss.
But they're also going by California law.
Are they?
Well, they haven't declared that yet, but I think that's
they're citing
what's going
Rule
to
11
happen
of the federal rules. Oh, Rule 11 is here again.
They're also talking about New York anti-SLAPP, so that's confusing.
Well, anti-SLAPP under New York and LA violates, I think it's Rules 11 and 52. They're not permissible in federal lawsuits. But if you go by California law, I think that's what they're going to argue, that you can be awarded 47.1 if the parties or if the court ruled that we're going to abide for California causes of action, that they would be permissible in that case, because it wouldn't be fees under federal law. We're imposing California law where they're permissible. And so it's kind of like a loophole to get 47.1 awards into a federal case where they wouldn't otherwise be eligible. I think that's what they're doing.
It's under the notice and opportunity to respond and withdraw or correct the challenged paper. This is like Gingris's argument in his appeal.
But this one has more merit, though, because
it's under this 47.1. It's not under Rule 25 of Arizona state law.
26,
right, this is like
Mr.
It's the reverse of Gingris's argument. So it's like California's 47.1 has its own rule, but this is a federal lawsuit. So we should apply federal damages under federal law. But they're going to say, but it's a California cause of action. And if we're abiding by those laws under California, then fees should be awarded as they were intended under California law. And I think federal courts would honor that because we're not, well, just by virtue of the litigation. But it would if you're going strictly by federal rules be in violations of rules 11 and 52. Same as the anti-SLAPP rules for California and New York, which is what they argued in the other opposition.
Mm-hmm. Wow, this is complicated.
All right.
But it's interesting. It's
Omar,
interesting.
Michelle wants to know. Please, she says, please help with this fear. If Lively succeeds in getting the case against her dismissed, can she withdraw her case against Baldoni? He needs to be found innocent.
Can she withdraw her case? She can't just withdraw it without his permission.
So she's saying if she succeeds in getting his complaint dismissed, can she withdraw her case against him? I guess.
Oh, his case, no, because he's still entitled to damages if she's unsuccessful going forward with her claims.
Okay.
Because they've already responded, so the case is ongoing.
Right. So even if Baldoni's case is thrown out, he's still entitled to fees if he prevails in the litigation against him.
As a respondent, yeah.
Because he answered her complaint as a defendant.
Huh. All right. 1 second.
But what's the chances of anybody's case getting thrown out? Like 0.
Okay.
Right.
Got
Yeah.
it.
I mean,
Okay. Well, that
Not on
works.
these 12B6 motions.
mhm.
I wouldn't even, I mean, extremely unlikely under a motion for summary judgment, which will be in the future, but you never know. Yeah, I don't think anything is getting thrown out.
Okay. Well, I'm skimming through the rest of this here. We're like at the.
You wouldn't
end,
expect a summary judgment motion to work in the future, would you?
There's too many tribal issues. Not at all.
Yeah.
Not a chance.
What does that mean?
It means that there's no reasonable jury based on the undisputed evidence that could possibly find in favor of a cause of action. So it's going to be dismissed with prejudice.
Okay. Got it. All right. Well, we're almost at the end here. So let's see. Finally, awarding Lively damages under 47.1 would violate the U.S. Constitution because imposing treble damages. What are treble damages, Omar?
Oh, I think it just takes the thing 3x. It's a 3x multiplier.
Okay.
Where
got
is
it.
that?
Yeah,
in here?
Omar died, guys. He's
Oh,
not literally
Can you highlight
dead,
where
he
that
died.
is here? Where's that?
Yes.
Sentence?
Treble damages on unsuccessful defamation claims.
Yeah.
Yeah, okay. Would impermissibly burden the exercise of rights protected by the petition clause of the First Amendment under the Norr-Pennington Doctrine. Okay, we're going to skim through that. The Supreme Court has extended Norr-Pennington immunity to preclude liability for bringing a suit that, though based on genuine grievance, is nevertheless unsuccessful. Okay. Here, the pursuit of a civil claim against Lively brought before a federal court is plainly an exercise of a right protected by the petition clause of a First Amendment. Okay. Let's see. Let's skim through some of this. Yeah. I mean, we're pretty much at the end here. On the contrary, hundreds of pages of evidence demonstrate that a sound factual basis underpins the Wayfarer party's claims against Lively, and certainly no one could seriously accuse the Wayfarer parties of lacking both an objective grounding in fact and a genuine subjective intent and expectation to prevail, as would be required to bring this case within the sham pleading exception to the Norr-Pennington Doctrine. Okay. Conclusion, they urge the court to deny the motion in its entirety, and the alternative, the Wayfarer parties respectfully request leave to amend their complaint. And we're finally at the end here. Guys, I'm going to be talking about this some more tomorrow with Ashley, Brianna, Eve, and Elsrich at 11 a.m. Eastern time. So be sure to tune in for that. Omar's going to pop back in here in just a second, but I want to say really quickly, MB Shotzi, thank you for the super sticker. I appreciate you. I've seen you around the streams and I appreciate being here. Same with Just Ricardo. Thank you for the $2. Friedman Snark seems to be pumped with facts. Hey, I'm all right with that, brother. Thank you very much, guys. And Omar's back.
Yo.
We're at the end finally.
I kicked myself out. My Instacart guy's here.
Oh man, I mean, I'm jealous to be honest because it's 12:30 here and it's too late for delivery, but I shouldn't be eating that anyway, so it's fine.
Well, nobody Instacarted me anything fun, so.
Well, who Instacarted you something boring? Because I need to talk to them. about that.
I Instacarted myself. It's
That
just
makes
like
sense.
food and
That makes a lot of sense, actually.
Can you scroll up to the
milk
last
ready to go?
page real quick?
What's that?
The last page we looked at.
Oh,
Can you
yeah.
put that on the screen for a sec?
This one or
Yeah.
the one before that?
Yeah.
Okay.
Okay. Okay.
Oh, Ellsrich is here. Hey, Ellsrich. Yeah, I'll be with Ellsrich.
Who is Eldridge?
Who is Ellsrich? Who are you, dude?
Well, exactly. I mean, forgive me for just being unknowledgeable.
No, Ellsrich is great. She's on Instagram. She's on YouTube now. I think she just got up to 10K subs, so that's pretty cool. But she was the one on Popcorn Planet earlier, the co-host. They were doing that fundraiser.
Oh, y'all talking about the charity thing?
Yeah, that's Ellsrich. Yeah.
Yeah, that's how I caught you on Podcorn. I was like, oh, you were talking about it. I know who she is now.
Yeah, and
I
her
saw her on a
birthday
Podcorn today.
her birthday is technically today. Everybody in the chat, please say happy birthday,
happy
Elsie.
birthday.
Happy
How many
birthday,
birthdays
Elsie.
are we talking
Thank you for
about here?
being
How
here.
old?
She's definitely
Omar.
17.
I don't
think
have
she's
that rule,
17.
Bruce.
Yeah.
I'll ask a woman how old she is. I'll ask her how much she weighs. And you know what? Ryan Reynolds get pissed off all she wants. But if I got to pick her up, man, I need to know how much she weighs because, you know.
Omar,
What?
did you Instacart crack?
This has gone way off the rails.
No, man, I literally Instacarted like milk for the girls and some snacks for lunch.
Okay. Well, she's 30. She's 30, she said.
Oh, happy birthday. Just a
Yeah, happy
youngster.
30th birthday.
Mm.
Sorry about my friend Omar here. He's clueless. Somebody says, if it's not Lauren tripping, it's Omar. Dude, you should see us both at once. It's bad.
Mhm.
You
All right,
got to
everybody.
see us like on a Friday when we're all like super lubricated on some kind of alcohol of choice.
Sorry,
I don't know.
is it Wednesday night? What night is it? It's Wednesday night, right? No, it's Thursday. What day is it?
It's Thursday night
Fuck. Okay.
already.
It's Friday for you already.
Oh shit.
You had some
that's
legendary
awesome.
streams, man.
I'm like, that's awesome. This is amazing news. I didn't know it was Friday. No, I did know. It just took me a second to get there. Alma Grizzle Alexander, thank you for the $3 super sticker. I appreciate you. Thank you for being here. Again, happy birthday, Elsie, one more time. And I'm going to take off for the night because I'm going to wake up early tomorrow morning. She says Oregon, Wisconsin sounds fun. Right.
I mean, there's at least one restaurant. I don't know.
Does it serve only cheese? I mean,
Thank you so much. I mean, that's the general area I'm looking around.
So cheese is like the Wisconsin staple. What's the Oregon staple?
What?
Cheese. You know, Wisconsin is the cheese thing, right? But
Yeah.
like,
What
what's
is the
for
Oregon staple?
Yeah.
Powdered
Oregon?
milk?
Oregon is well known for Pinot Noir wine. Oregon
right,
is well known for hazelnuts or filberts. Some people call them filberts. Hazelnuts. What else is Oregon known for? I don't know.
Chestnuts.
Hazelnuts.
Or no. Hazelnuts.
Omar.
Yeah.
It's hard to
Oregon
pretend
has,
like I know things. I don't know, man. I have no idea what Oregon is famous for.
Oregon has a long and disturbing history around racism, unfortunately. So, yeah, that's true.
Well,
What the hell? Okay, hang on. That's not the staple we're looking for. Anyways, I'm gonna pull up Elgis's link right here.
Yes,
Hang
there's
on.
plenty of invasive blackberries in Oregon. That's for sure.
Please subscribe to Ellsrich. I'm putting the link in the chat right now. I'm gonna pin that real quick if I can get the chat to slow down.
With the
Jesus Christ, there's a
thorns.
lot of you guys here. Here we go.
They taste good,
And,
but the thorns are terrible.
Yes, please subscribe to my friend Ellsrich. I will be with her and
Mhm.
Ashley Brianna Eve tomorrow.
Awesome.
And I will see you guys there. Bruce from Oregon, thank you for streaming with us, as well as Omar, even though you popped in and out. I totally do the same thing to you.
the
And we are good, guys. We are
Oh my
good. I'm
gosh.
gonna get some sleep and I'm gonna
Yeah,
be
we
back
got to get up
tomorrow.
early for that reality Steve debate. Oh my
Oh my
gosh.
god,
guys.
there's
I'm
so
gonna-
much happening tomorrow. And don't forget Omar, especially
I don't know how I feel about that. I mean,
Oh, dude, I don't
I
either, but we're gonna find out, aren't we?
I still feel like Gingras needs to apologize to Dave Neal, Dave Neal's family. He needs to make amends for his rudeness in the past.
That guy's
don't-
got
I'm feeling it's not
he's
coming,
got
man.
way too much sand in his vagina for that to ever happen. All right.
He's got a chapped vagina.
Bruce says, "Oh," because he knows what it feels like when he has too much sand in his vagina.
That's true.
You know,
Amy-
sand and
Amy-
cracks is a problem.
Amy, apparently Reality Steve recorded a debate between Rachel Juarez and David Gingras, and it's going to air tomorrow morning. So
Oh yeah. Oh
there
yeah.
you go.
I'll be doing that. I'm going to do some, after you're doing your thing, I'll probably be, I'm doing Karen Reed tomorrow.
Oh, interesting.
I got a Karen
Okay.
Reed strain.
Yeah.
I'm going to try to
Omar,
get to
she's
some
really
live
vulnerable
stuff.
right now. You shouldn't do her.
When I was
Well,
sick, I
not like
watched a
that,
lot of
Lauren.
Karen Reed videos, so I'm trying to catch up on that case.
Yeah, well, they're picking juries right now. And
Yeah.
so that trial is about to kick off. And so that's going to take up a lot of content space. So anyway,
That's
I'm doing that tomorrow.
big
And then
trial.
Flad, if Bruce may join, if I can maybe
Ugh.
switch up the time. I don't know, man. He's got like his Dungeons
My
and Dragons
friends-
thing.
They wanted to game every other Friday, and now they're like, oh, maybe we'll game every Friday. And I'm like, this is exactly when Flad is. Like, Flad needs to be like, can you make it like 7 p.m. Pacific? Or I don't know.
I mean, I'd like to do that, but it's starting to catch on at the time slot that it's on now. Like we had
Yeah.
a really big audience last week.
Oh, nice. Okay.
And
I mean, yeah, I don't have to go to the gaming. I can do Flad.
What
tomorrow.
time was it last week?
It's 5.
well, we've been doing it at 5 p.m. Pacific.
Oh yeah, that's a great time.
So it's actually after dark as opposed to like during the middle of the workday.
That's prime. It's not dark in Oregon, by the way, but
Oh, or where I'm at either. But, you know, most of our people are on the East Coast that watch the show anyway.
Yeah.
Anyway, it's been working. And so I'd like to switch it, but I can't keep switching it all the time, you know? But,
well,
yeah,
I'll try
we'll
to
be doing
attend.
that. Maybe Brad will be there.
Because I
Maybe
miss
Bruce
it.
will be there. Yeah, maybe Schnitzel will be there. We'll never know. I might have another person auditioning for a spot, a regular. We'll see.
Oh my.
Whoa.
We will see. Maybe Lauren, if she's not too busy with her, whatever she does on a Friday night.
Lauren's a wild card. I hear she's unstable on Fridays. So. Just
Anyway.
hang in there, buddy. Maybe she'll join you. We'll see.
Well, Lauren, you should get your rest, man. I'm afraid about what happens past midnight with you.
It's already midnight, so you about got the worst. But
We're in the danger zone.
yeah, for sure. All right, everybody, bring your own cakes to Elsie's stream tomorrow. I'm gonna send you over to Valhalla for the goat cam. Tell him Lauren said hello. Send lots of bacon and robot emojis. This is the Bacon Bot Army. Say hello to the baby goats for me. And I will see you guys tomorrow. Don't forget, Jad Wallace, the Blake Lively response to Jad Wallace's Texas lawsuit is due tomorrow night. So I'll be on the lookout for that. And I will see you guys soon. All right. Bye, everyone.
Bye, folks.
Happy birthday, Elsie. Bye.
Happy birthday.
Happy birthday.